Jacuna Collins, please unmute your device, state your name for the record if you're present.
Judge, I don't believe that they are on Zoom and we'd be unable to proceed.
Defense moves to dismiss.
Thank you. The court will grant the motion to dismiss. It is without prejudice, meaning that if they are able to proceed at a later date and time, this case could be reauthorized. Mr. Williams, are you on any tether or anything like that? So
No.
then the case is now dismissed. All your bond conditions are over, and you didn't post any monies, did you?
No.
You're all set, sir. Have a good day.
All right, thank you, Judge.
Thank you.
All right, thank you, Mr. Williams. You can log off. You're all set.
Okay.
Cold call case of the state of Michigan versus Janet Savage, case number 25S00529.
Deputy works for the people.
Okay, we're all on behalf of Janet Savage. Ms. Savage, if you could please unmute yourself, turn on your camera, and state your name for the record.
Janet Savage.
Thank you. Good morning, Ms. Savage. We're here today for a final settlement conference.
Yes, Judge, the victims in this case are Kenneth Taylor and Tammy Taylor. If Kenneth Taylor and Tammy Taylor, if you're present, please unmute your device and state your name for the record. Kenneth Taylor or Tammy Taylor?
Kenneth Taylor or Tammy Taylor, if you are present, please unmute your device and state your name.
I do not see that they are present on Zoom and we'd be unable to proceed.
Defense moves for dismissal.
Case is dismissed because the prosecutor is unable to proceed.
Okay. Thank you, Judge.
That's without prejudice, sir, meaning that if there are any, if they're able to proceed at a later date and time, it could be reauthorized. Are you on tether or did you post any monies?
No.
Janet, you didn't post anything. You're not on tether, right?
No.
This case is
No.
followed. All your bond conditions are now over.
Thank you, Judge.
Thank you. Thank
Janet,
you.
you're
Have a
all
good day.
Thank you.
All right.
Roll call case of Ypsilanti Township versus Sylvia Johnson, case number 23T00046.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Trovia Star on behalf of Miss Johnson, who's right next to me. Miss Johnson, state your name. I think I'm blurred out. I'm sorry.
Sylvia Johnson.
All right, we're here for final settlement conference.
Yeah, that's correct, Your Honor. We are ready to proceed to jury selection if that's what the defendant wishes to do. I did extend an offer of operating while visibly impaired. I don't believe she wants to take that, but I'm happy to make that offer.
Your Honor, I did convey that offer to my client. At this time, we wish to move forward with the jury trial. I believe it's currently scheduled for May 2nd.
May 1st.
May 1st, excuse me. 2nd is a Saturday. May 1st. Even though I'll be here on Saturday if you want me to be here.
Thank you. All right. Jury selection will continue on to May 1st, 2026 at 8:30 in the morning. And I know that she knows how that process goes. We've been there
Yes.
before. So we'll see you all on May 1st at 8:30 a.m. We'll pick our jury.
Your Honor,
We did have a motion up for video testimony of the Michigan State Police Crime Lab scientist in this case. So I'm asking that she be allowed to testify via Zoom or other video means for the trial.
Your Honor, yes, a motion was filed, and I'd like to apologize for not submitting a response. A few days after that motion was filed, my grandmother passed away, and I had to go down to Georgia and visit her. And right now, it's her memorial service right now. So I'd like to respond on the record. This is a discretionary thing here in terms of allowing this person to come. But I would just like I like to point out to the court that I believe we changed the dates around so this person could come here to testify. I I believe last time we were here, the dates were different in terms of final settlement conference and jury selection. Well, mainly jury selection. And the dates were changed so the prosecutor could get that person here. For that reason, because that accommodation was made, I'm asking for that person to be here in person to testify.
Just to clarify, I don't believe we changed the dates so the person could be here in person. This is a individual who does testing for agencies throughout the state. The day that I had subpoenaed her for video testimony, the last time, she actually had 3 other locations that she was video testifying to at the same time. So the adjournment was to ensure that she was available via video. So again, and I'll just rest on my written motion.
Video testimony is allowed.
Thank you.
The court feels as though our counsel will have the opportunity to confront her via video as readily as they could in person and with this type of lab testimony.
Understood, Your Honor. Thank you.
Thank you.
We'll see you on May 1st. Bond is continued.
Thank you, Your Honor.
Profile case of the state of Michigan versus Donald Carlton, case number 26S00009.
Tiffany, what's for the people?
David I. Goldstein, appearing on behalf of the defendant.
Mr. Donald Carlton, please unmute your device and state your name.
He might be labeled as Matt Magbury.
Yeah, he's there.
Donald Carlton.
Thank you.
We have a number of people lined up for the Zoom, so I have them all noted online.
Judge, I believe the victim is Tammy Rich and she is present on Zoom. Miss Tammy Rich, could you please unmute your device and state your name for the record?
Tammy Rich.
And Judge, we'd be able to proceed on this case.
Mr. Goldstein.
Your Honor, there is a trial date, jury selection date, May 1st. It's in my calendar. I don't believe any offer has been made in this matter, but we're ready to go to trial if necessary.
Did your defendant want a plea offer?
I always communicate them, whether he wants it or not is his decision, but I always communicate any offer.
I just got placed on this docket a week ago or so. I'm new to it, so.
All right, well, why don't we pass it to May 1st and you and I can talk in the meantime.
That sounds good.
Jury selection, May 1st, 2026 at 8:30 a.m. The jury will be here and present. Bond is continued.
Thank you.
Thank you.
David, call me.
Sorry, Donald?
Call me.
I will.
Thank you. You're all set, Mr. Carlton. The cold call case of the state of Michigan versus Shirley Roberson, case number 25S00337.
Tiffany Woods for the people.
David I. Goldstein, appearing on behalf of the defendant. Ms. Roberson, turn on your camera, please.
Yes, I'm here.
Please state your name.
Shirley Roberson.
Thank you. We're here for final settlement conference today.
Yes, Judge. The victim in this case is Kevin Blackwell. Kevin Blackwell, if you're present, please unmute your device and state your name for the record. Kevin Blackwell. Judge, I did not see Mr. Blackwell on Zoom. I would be unable to proceed.
Move to dismiss, Your Honor.
Given that the prosecution is unable to proceed, I will grant your motion to dismiss. It is without prejudice. And if they're able to proceed at a really big time, could be reauthorized. Are you on tether or anything like that?
No, ma'am. No, ma'am.
You're all set, ma'am. Your bond conditions are over.
Thank you.
Thank you, Ms. Woods. I'll be in touch with you next week about Carlton.
Thank you.
Roll call
Thank you.
case. Thank you. The roll call case of the Ypsilanti Township versus Daryl Gardner, case number 13T00166.
Paul Barnett on behalf of the township.
Mr. Damian Cash.
Oh, Your Honor, I apologize. He had sent a message. She's putting.
Yes, I'm here, Your Honor.
Strict. Oh, okay. I apologize.
Could you please put your appearance on?
My apologies. Attorney Damian Cash, P number 85852 on behalf of Mr. Daryl Gardner. Mr. Gardner, if you could hear me, set your name for the record.
Daryl Gardner.
Thank you, sir.
Yes, sir.
All right, we're for conference.
That's correct, Your Honor. This time the township is not in a position to proceed to trial.
Your Honor, then on Friday, my favorite thing to do is make a motion to dismiss for not being able to confront our computer, Your Honor.
Given that the prosecution is unable to proceed, I will grant your attorney's motion to dismiss, sir. The dismissal is without prejudice, meaning that if they will proceed at a later date, they could reauthorize this case. And I think this case is over. This is the only thing holding you would be released, but I think you have another matter. And then correct?
Yes, ma'am.
Thank you. You're all
Thank you.
set, sir.
Thank you. Thank you, Mr.
Your Honor.
Cash.
Hey, good luck, Mr. Gardner.
I appreciate it.
Hey, you're welcome. Have a good one. Bye.
You too.
The court called the case of the state of Michigan versus Deonte Johnson, case number 23S00072.
What's for the people?
Ashley Moulton on behalf of Mr. Johnson. Please state your name, sir.
Deonte Johnson.
Thank you. For your final settlement, counsel.
Yes, Judge. So the victim in this case is Sharina Jones Stewart. Sharina Jones Stewart, if you are present, please unmute your device and state your name for the record. Sharina Jones Stewart. And Judge, I do not believe that Ms. Stewart is present on Zoom and we would be unable to proceed.
The defense moves to dismiss.
Given that the people are unable to proceed, the court will grant the motion to dismiss. It is without prejudice, meaning that if they're able to proceed at a later date in time, this case could be reauthorized. This has lien conditions that, are you on time?
No.
They have lien conditions that will not be removed until 24 hours. So please do not have any contact. I don't think you're supposed to be anyway. So, I don't know if there are other reasons why you can't, other than this case. But based on the nature of the charge, it probably makes sense that you're not.
Thank you, Your Honor.
Thank you. Court will call the case of Ypsilanti.
Yes.
The court will call the case of Ypsilanti Township versus Magbury, case number 25T00522.
Paul Barnett on behalf of the township.
Ashley Moulton on behalf of Mr. Magbury. Please state your name, sir.
Not Magbury.
Thank you. We're here for final settlement conference.
That's correct, Your Honor. This time the township is not in a position to proceed to trial.
The defense moves to dismiss.
Given that the people are unable to proceed, I will grant your attorney's motion to dismiss. Mr. Magbury, it is without prejudice, meaning that if they will proceed at a later date time, it could be reauthorized. You should follow all the lien conditions for 24 hours until they're out of the system, so you should not have contact because it might be in the system still and you get it picked up. Okay?
Yeah, but I ain't got to go to community corrections or nothing no more, do I?
No, no more testing. All the other conditions are over, so
Thank you.
you're welcome. You're not on tether, are you, sir?
No,
No, you're all set. Have a good day.
thank you.
You're welcome.
Add on.
All right, roll call case of the state of Michigan versus Brian J. Wu, case number 26S00062.
Tiffany Woods for the people.
Ashley Moulton on behalf of Mr. Jewell, please state your name, sir.
Unmute.
Unmute.
Brian Giroux.
Judge, we are setting this case for a pretrial.
Right.
Charge. So you made a Monday date. How far out are they looking for? 5, 6 months. We do May 18th, sure.
May 18th, 2026 at 9:00 a.m.
Thank you, Judge.
Trial sorry, is continued.
Okay. All right, good morning. Court calls case BO Properties versus Going Robbins.
Good morning, Honor. Dana Hall on behalf of Beal.
Going Robinson? Here. Oh, good. Come on up, sir. You're in the courtroom. Come on. Hello, sir. Hello. Hello. All right. What is plaintiff's claim in this case?
Your Honor, did you say Robinson?
Yes.
I'm not seeing a Robinson. I have a
He's present in the courtroom. Your name, sir? Colin Robbins. Yeah.
Okay, just a second. I don't see that I have this one. Can you hold on just 1 second?
Sure. Let's do this. Mr. Robinson, you can have a seat right there. All right. And then I'm going to pass your case and she's going to find the paperwork. You can sit wherever you like, sir. Okay.
Thank you.
Thank you. BO Properties versus Micah Fry.
Okay.
What? Micah Fry? Counsel, if you wish to proceed, raise your right hand.
I'm not finding this neither, Your Honor. I'm trying to check to see if maybe they were dismissed.
I'm sorry?
I'm trying to check to see if perhaps they were dismissed because I'm not. I don't have.
So you have all the BO property ones, correct?
Yes, I do have a couple other Beals, but not those two.
Okay.
I don't know.
So this is the way to start. No, it's okay, Miss Hall. Here we go. This is what I'll do. I'll pass that one too. And then let's try this one. BO Properties versus Nathan Barnes.
I do have that one.
Okay, yay. Nathan Barnes. Not checking. If you'd like to proceed, raise your right hand, please. Do you solemnly swear for testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right.
Your Honor, this is a non-payment
Sir?
of rent matter.
Hang on. Did you say Mr. Burns is here?
Yeah, he just.
Yes, right here.
Oh, okay. Hello, Mr. Burns.
Sorry, I was.
All right. No, it's okay. What is plaintiff's claim?
Your Honor, this is a non-payment of rent case. I'm showing the past due rent is $1,914. Court costs are $175 for a total of $2,089.
All right. And Mr. Barnes, how are you intending on getting that paid?
I was laid off my job for a little bit. I wasn't working. I am going back to my job at noon today. So, I plan to make the payment. I'm still waiting on my taxes. Shouldn't be too much longer. So
all right. Here's what I'm going to do. I'm going to adjourn you out to next week, the 24th, 2026 at 3 p.m. That's an in-person hearing, sir. What I'm going to suggest you do is contact the attorney's office between now and then and see if you can work out some type of an agreement as to how you're going to get this paid back.
Okay, so the attorney's office would be where again? The 14th.
Jared Levine. On your paperwork, you will see a phone number for the plaintiff. Plaintiff's attorney. You'll see it at the top. I think it's on the right-hand side. Well, okay. My eyes are good, but not that good. I can't read that.
My bad.
Do you see that?
Is it Meskio Courts? No, that's the Zoom.
No.
What
Do this. Let me just give you the phone number.
Okay.
All right. It's 248-851-8000.
And I have a trial to come into court. You said in person at the 14B on the 24th?
At 14A1 on the 24th at 3 p.m.
Okay. Sounds good.
All right. Okay. Thank you.
No problem. Am I good to go?
Beal Properties versus Matata Patrick. Matata Patrick. Oh, there you are.
Yes.
All right. What? Yeah, I got you. Can you hear me?
Yes.
All right. What is plaintiff's claim?
Your Honor, I'm showing that at this time, this is a non-payment of rent case. I'm showing the past rent is $2,131.32. Court costs are $175 for a total of $2,306.32.
All right. Folks, how are you intending on getting that paid?
Good morning, Your Honor.
Good morning.
I have been communicating with the homeowner via email, and I believe Mr. Bill's been CC'd on the email as well, and I believe we come up with an agreement. My agency has agreed to pay the current rent along with some other things, utility allowance.
Okay, ma'am, can I just stop you for a moment?
Sure.
Who are you?
I'm his case manager. We provide a housing subsidy for him currently.
Okay, thank you. I just was trying to work that all out. Okay, so you go ahead. I'm sorry, I interrupted you.
No, that's okay. So talking with our grants people, we really aren't able to do anything until we move Mr. Matata and his family out of the house. So that was also part of the agreement. That once he and his family are out of the house, we can use another payment, another grant to pay the back rent. I sent this over and it's all been communicated in email, and I sent a letter on letterhead. I believe that must have been like Wednesday, and I thought we had an agreement already on that. So yesterday, I believe, or it was Wednesday or Thursday, I sent the payment for his April rent. I actually dropped that off at Mr. Beal's office, actually, and notified them both that it was paid.
Do you see that, Miss Hall? No.
No, I can look. How much was the payment for?
The payment for April was the $1,760, which is his typical monthly rent, and that was part of the agreement. If you give me an email, I can forward you the chain of emails, or I can forward you the letter. I think the chain of emails may be more helpful, though, because it shows the communication.
Let's do this. First thing, I'm going to adjourn this out, see if we can get all of this clarified. It looks like at least a majority of this may have already been paid. So I'm going to adjourn this out to the 24th, 2026 at 3 p.m. That's an in-person hearing, ma'am, so that you understand that. And ma'am, for our record, I need to have your name.
My name is Summer, last name Burrell.
Got it? Okay.
I'm sorry, Your Honor, the time was?
3 p.m.
Thank you.
Thank you.
Can you see the chat? I could send my email address in the chat.
Yeah.
Okay, I'll send it up.
Okay. BO Properties versus Edward Smith. Edward Smith, no response. You may proceed, counsel.
Your Honor, I'm showing, this is a non-payment of rent case. I'm showing past due rent of $1,473 for a cost of $175 for a total of $1,648. Requesting a default judgment for possession only, giving defendant until April 27th to pay or move.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. BO Properties versus, is it Monahaja?
It's Monasia Brown.
No, it's not. Okay, yeah, it is.
Yes, sir.
It's your name. So it's your name. That'll work. All right. I need a camera, ma'am.
Okay.
All right. Good morning.
Good morning.
All right. It's pronounced
Monasia Brown.
Monasia?
Monasia.
Okay. Monasia. Got it. Okay. I would expect to be, but that's all right. All right. Counsel, what's the claim?
Your Honor, this is a non-payment of rent matter. The past due rent is $6,255. The court costs are $175 for a total of $6,430.
All right. Ma'am, how are you intending on getting that paid?
So I intended on paying my rent by working my job and getting legal assistance. I applied for SCR and I was denied, and I have the papers here if you would like to see them, but I was denied upon my SCR for rental assistance as well as DTE assistance because I did not fall into compliance with child support. But then when I fell into compliance with child support, the other person did not fall into compliance. So my SCR has continuously been getting denied. I moved into this unit as of December 1st of 2025 after moving from 721 Green Road, apartment 221, which was
so
not...
you are in Arbor One.
Yes.
Okay.
So when I went into the Arbor One leasing office today, they actually have new management, and I believe I have the paper around me, which is called Ram Apartments. But the last time I went in there to speak to the lady named Jessica Nice, I agreed upon this notice, which is a move-out agreement to Dear Arbor One Apartments. Due to the eviction notice at 721 West Clark Road, I am making this decision to avoid the eviction process and vacate the unit by May 29th. If anything changes regarding the date I choose to vacate, I will update the leasing office. But when I went in there, it was a new lady, new management. Now, we've had 3 management companies. So when I moved in from December 1st until now, they also fell out of compliance, which I have emails regarding that. So my rent is not even updated to the correct amount, which they refuse to update.
All right. Miss Brown, do me a favor. I know there's a lot there. Just take a breath. Okay. All right. So are you saying that this rental amount is in error?
Yes, it's incorrect.
Okay. All right. So let's do this. First thing that I'm going to do is I'm going to adjourn your case out to next week in person.
Mm-hmm.
Okay. So that'd be April 24th, 2026 at 3 p.m. Okay. That's an in-person hearing.
Okay.
You said you already applied for SER and been denied. Have you applied through Hawk?
No, sir.
All right. What I'm going to suggest is that you call Hawk, get an appointment, see if there's a way that they might be able to help you out on this. Okay. That's one thing. Okay. Do you have that number?
Yes, sir.
Okay. It's on your paperwork.
Okay. May I make a note on this case as well?
Pardon?
May I make a note as well? Because regarding the paperwork that I written with the prior leasing agent, Jessica Nice, I have through email that she was allowing me to vacate the unit and not pay this balance.
All right, ma'am, I heard you. I don't have any of that in front of me right now.
Okay,
just
thank you.
Bring that paperwork with you when you come to court on that day. All right. Now, the other thing that you said is, and I just want to make sure, see if I'm understanding what you told me. Were you required to pay child support and fell out of compliance, or reporting child? What was that about?
So the child support was regarding a DNA testing for my child. So when I tried to apply for assistance, they denied me because they said I didn't respond to them and I didn't have the correct information. So that backtracked me a while until I got, set up with them.
Okay, let me ask you this then, and maybe I'll ask it a simpler way. Are you supposed to be receiving child support?
Yes.
Gotcha. Okay. So here's the other thing I'm going to do for you. Okay. We have Miss Mazur here from the friend of the court. Would you mind if I put you into a breakout room with her and see if you can? Wow, that was a big smile.
I would love that. Because I have my case number right here. I would love that.
I'm sure she'll be able to find you in that. So, and see if at least those issues can then be worked through to maybe help you out in this, if you're supposed to be receiving, and if there's an issue as to how that may need to occur.
Okay.
Fair enough?
Yes.
Okay. So I've got you set for April 24th, 2026, 3 p.m. Miss Mazur, are you there? She's usually right there. Yeah. All right, we're prompting her. And then, oh, there she is.
Sorry, Judge.
No, it's okay. Being a Maryland guy, I was just waiting to see that Michigan versus everybody in the background just to irritate me. All right.
Oh, yeah.
All right. We have Miss Brown here. She's got a child support issue. We were going to put you into a breakout room if that's okay.
Perfect. That works.
All right, Miss Brown, and we'll see you next week.
Okay. Thank you.
You're welcome. So just hold the line. We'll get you there. Beal Properties versus Maisha Sampson.
Good morning. I'm here.
Good morning, Ms. Sampson. All right. And what is plaintiff's claim in this case?
Your Honor, at this time, I'm showing past rent of $7,812.03, court costs of $175, a total of $7,987.03.
All right. Ms. Sampson, how are you intending on getting that paid?
Well, I'm not, because I plan on relocating, and that is because I am in Arbor One, and for 8 months they charged me rent, and I didn't know we were in non-compliance.
Hang on a second, Ms. Sampson.
Mm-hmm.
These are Arbor One cases?
Yep.
So, no, that's not. So, the 721-208, is that Arbor One?
Yes.
Are they permitted to proceed? Yeah, go ahead, Ms. Sampson.
Okay, so when I went into the office, I spoke to Jessica maybe 2 weeks ago just to get a key because I didn't know we had mail. All of this is, and she told me that we would be getting new property management and anyone who has a back balance will be cleared out. That's just what she told me. However, the thing, this amount that in the whole process, I became disabled. I got cancer in my hand, laid off. But during this whole process of when it first started, I was being charged rent from September to March. And I didn't know until Jerry knocked on the door and said, hey, stop paying the rent. And I'm like, okay. So they technically owe me $8,000, but I just moved forward with that because I'm sick now. And I just applied for SSD and that's pending. And I don't even know who the new landlords are to pay, or I just got to move forward with my life and my healing because it's a lot going on that I just wasn't aware of. And I'm like 50 and I've never done this before or rented before. And if I gotta go, I've been packed up, ready to move for almost a year because I don't know how this go. It'd be compliance, non-compliance. I give them some money.
All right, Ms. Sampson. All right, do me a favor.
Absolutely.
Sounds like you got a lot to worry about. Right now, I'm going to adjourn this out 1 week to the 24th.
Okay.
2026 at 3. That's an in-person hearing.
Okay.
One of the things I've got to check on, because there was litigation regarding Arbor One.
Yeah.
I'm a bit unclear about these proceeding forward. Because my understanding is there's a federal suit as well as a suit in the circuit court of this county that may cover the Arbor One properties.
Yeah.
And so I have to figure that out. Okay.
Okay.
So what I'm going to do is I'm going to adjourn it out a week to the 24th at 3 p.m. That's in person.
Okay.
Okay. And so between now and then, I don't want you worrying about it. We'll sort something out next week. Fair enough?
Yes, I appreciate it.
Okay, Sampson, you take care of yourself, okay? We'll see you next week.
Okay, you take care. Thanks a lot for everything.
Thank you.
You're welcome.
All right. Counsel.
I did locate Robinson and Fry.
Right, but I'm going to have in Arbor One. So, counsel, do you know about cases in Arbor One proceeding?
I know a little bit about those, Your Honor. I'd have to have some time before the next hearing to look into it more. I did want to let you know we do, if it's helpful to you at all, have a representative from the new property management company here if you wanted to ask her any questions. But as far as the litigation and the other, I'm not positive.
Right. Well, and because at least as I understood it, I stopped following it in detail once my Arbor One cases had left. But I don't know whether Judge Kunke gave authority to proceed on any of those properties, number one. And there's also a federal suit that was pending. And I don't know what impact it has. And I'm going to need some clarification as to that. Okay. So, Mr. Robinson, sir, here's what I'm going to do. We checked your address and you thought that was Arbor One, right? Yeah. Okay, Mr. Robinson, I'm going to adjourn your case out to the 24th 2026 at 3 p.m. Okay, so you'll have to come back at that time. And then hopefully what'll happen is I'll have some clear, I'll be clear as to whether or not these should proceed or how they should proceed.
Okay.
Okay, Mr. Robinson, thank you for coming down. I appreciate it. You take care of yourself. And then also on the case of BO Properties versus Micah Fry, I'm also going to adjourn that matter, that being in the same situation, to the 24th, 2026 at 3 p.m. All right.
Okay, I'll look into that, Your Honor, and get an answer by the next hearing.
All right. Fantastic. Thank you, Coach.
Okay, so that's awesome. Thank you.
Thank you.
Your Honor, this is Mr. Curry, and I had the same situation. I'm in they gave me a eviction notice in 721 as well. I'm sorry to cut you off as well. So,
what's your first name? What's your full name?
Antoine Curry.
Your case was dismissed, sir.
Okay, thank you.
Thank you. Arbor Meadows versus Marilyn Pago.
I'm Dana Hall on behalf of Arbor Meadows.
Check.
Pago, not checked in. You may proceed.
Your Honor, this is a non-payment of rent matter. I'm showing a past due rent of $1,626.47, cost of $175 for a total of $1,801.47. Requesting a default judgment for possession only, giving the defendant until April 27th to pay or vacate.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Arbor Meadows versus Carlos Quijada. Carlos Quijada, you may proceed.
Your Honor, I'm showing past due rent at this time of $990.80. Court cost of $175 for a total of $1,165.80. We're requesting a default judgment for possession only, giving the defendants until April 27th to pay or vacate.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with a writ to issue in 10 days.
Your Honor, may I swear in Charlie?
Yes, you may.
Good afternoon, Charlie. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. We need your assistance with one matter today.
Section 23 of the lease that the landlord may terminate this agreement upon the criminal activity by tenant, any member of the tenant's household, a guest, or other person under the tenant's control that threatens the safety, health, and the right of peaceful enjoyment of the premises of the residents. There was, whether it was the defendant or whether it was somebody in his household, there was video of a shootout with persons from his household coming out with guns. We attached to our complaint a copy of what we believe the defendant to be walking through the parking structure or through the parking lot with holding a gun. The video showed muzzle flashes from various guns. We'd like to order eviction as soon as possible.
Mr. Hill, what is your position on this?
I'm moving out. The only reason I'm in here today is to get rid of the furniture in the house.
Okay, so will you be out by next week?
Yeah.
Okay, so do this. You're going to be out, turn your keys into the management office before next Friday, okay? All right, and what I'll do is I'll adjourn the case out to April 24th, 2026 at 12 noon. All right. So try to get all that done before 12 noon, and then likely the case will be dismissed.
Okay.
All right. Thank you.
Thank you, Your Honor.
Thank you.
Always a pleasure.
Personal versus Khalid Hamad. Med.
Yes, actually, this is Shaima Akrad, his mom.
Good morning, Your Honor. Jillian Engen for.
Oh, she's tenant too.
Yes.
All right. All right. I'll need a camera, ma'am.
Sorry.
All right. Thank you. No, it's okay. Oh boy, I got two people from the Fink office. I know.
And we
They're both in I know. What's the deal? Is Jim wearing that same color?
No.
Never mind.
This is the first time I've been in your courtroom since 2012, Your Honor. So
I know.
Be forgiving and patient, please, as you always are.
All right.
I was so happy when I came out and I saw the Zoom screen. I was so happy to see you, but I didn't want to stop and not continue on with the cases. But it's great seeing you. All right. What are we doing on Miss Akrad's case? What are we doing?
Your Honor, I have a balance including court costs of $632.
All right. And ma'am, how are you intending on getting that paid?
Is that just for the court or is it for the apartment, for the rent?
So I have rent to retain in the amount of $412 plus court costs that were incurred in filing this case for court costs are $220, but the total that needs to be paid to your landlord in order to stop this case would be $632.
Okay, I will take care of that today, actually.
Okay.
You will? Okay. So here's what I'll do. I'll adjourn it out to next week, the 24th, 2026 at 2 p.m. And ma'am, if you have it all paid, get it all taken care of, this case is going to be dismissed.
Okay, thank you.
Okay. Thank you, ma'am.
Bye-bye.
Have a good weekend.
Thank you, you too.
Forrest Knoll versus Tequila Smith.
Jillian Engen for plaintiff.
Hello.
Hello. What's your name?
Tequila Smith.
All right. What's the claim in this case?
Your Honor, I have a balance including court costs of $701.38.
All right. And Ms. Smith, how were you intending on getting that paid?
I paid it already. I paid it down to zero.
You said you paid it already?
Yep. It's my balance is zero now.
Okay. When did you get that paid?
They told me to get on here and show y'all the receipt that I paid. At that moment, I paid $514 last night because I had already paid on it before they put this court notice in. I just didn't know they put it in.
Okay. So you think everything's paid?
But my balance is $0 now.
Well, okay, I hear you. But you think everything's paid, correct?
Yep, most definitely.
All right. Then what I'm going to do is I'm going to adjourn this out to the 24th, 2026, 2 p.m. And then if everything's paid and it's truly down to zero, this case is going to be dismissed. Okay, Ms. Smith?
Your Honor.
Okay, thank you.
Oh, excuse me. Hang on a second. I'm sorry, Ms. Engine.
I'm sorry. So I don't see on the ledger that the court costs were added. So those are going to be added to the ledger. Those are $175 total. So Ms. Smith, that will need to be paid in order to get a dismissal on this matter.
Okay, so you said $175?
Yes, ma'am. And I'm going to let your landlord know that they should put those on the ledger so you can see that there.
Okay, $175. Okay, thank you. I'll try to get that paid off for the next court date.
All right, thank you.
All right. Real good. Thank you.
Okay,
thanks. Your Honor.
sign.
Okay. Okay, thank you. Is that it for you, Ms. Angel?
Yeah, I'm just gonna hand it over to Alicia now.
Oh, boy.
We're tag teaming today.
Let's see where this goes. All right. Omar Kareem. I think it is, or Kareem Omar. How'd they put this name in?
It's Kareem Omar. Kareem is the first name.
All right. I don't know why they entered it this way. Versus Ashley Darden.
Alicia Fink on behalf of Mr. Omar.
I'm restricted.
I'm sorry. Well, the attorney's here. This is a termination case.
Yes, sir. Your Honor, this is a case where there's a criminal matter pending in front of you also.
Yes.
And I don't know if you recall that Mr. Simon is representing Mr. Omar in that matter, and that there was something put on the record saying that there was an agreement that we could pursue this at this time, but that possibly the writ of eviction wouldn't issue until that other matter is resolved. And Mr. Simon told me that you have a bench trial scheduled for Monday, the 27th.
Right. And I don't know if that's between that agreement, maybe between the prosecutor and
I think it was just put on the record that the prosecutor wasn't going to hold it against Mr. Omar as any kind of violation of a no contact order.
Do you recall that? Okay. Oh, we had a bench conference. I don't know what was based on the record.
Maybe nothing was placed on the record. I wasn't there, but my understanding was that this was going to be able to go ahead despite the fact that there's that other matter pending, but that the writ of eviction might have to be delayed.
All right. Then I'll do it this way. Raise your right hand. You solemnly swear from testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
All right. And what is the claim in this case? Seeking to terminate the tenancy pursuant to notice.
Yes, sir. The defendant does not have a lease there and has been living in the apartment with Mr. Omar's permission, but has not moved out despite the requests by him and my office that she do that.
All right. What I will do is I'll grant a judgment for possession, no redemption amount, writ issue. What is my writ date? 17th would be the 27th.
The 27th. So that's the day of the trial. Should we bump it a little after that, just in case?
Yeah, that's what I was thinking. Writ to issue the 29th.
Okay.
All right. We'll do it that way. All right. Thank you.
Yeah, it's been a long time. Not since I've seen you, but since I've been in this spot.
Doing that spot. It's great to see you.
Good to see you too. Take care.
You do the same. Ian Greenlee versus Bridget Martin.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
And Charles Fletcher. Martin.
I'm here. Sorry. Gosh.
No, it's okay.
I'm not used to doing Zoom. Sorry.
It's all right. Okay. Mr. Pantera, what is the claim?
There's rent owing in the amount, including court costs, of $6,183.
All right. And Ms. Martin, how are you intending on getting this paid?
Well, I moved out on November 26th, and Charles Fletcher is refusing to move out, so I don't know what to do. I turned the power off. The power has been off at that apartment since December 2nd, so I don't know what to do.
So you voluntarily surrendered?
My lease was up December 1st and I left.
Gotcha. But he hasn't done that. So here's what I'm going to do. Mr. Fentera, raise your right hand. Do you solemnly swear or affirm testimony regarding the amount that's owed is true to the best of your knowledge, information, and belief?
I do, Your Honor. Would you like me to break down the balance between rent and court costs?
Yes, please, if you could.
It's, there's rent of $5,995. Court costs of $188 for a total of $6,183. And I will say, Your Honor, that what Ms. Martin is saying, I believe is true. She has Section 8. And in fact, I think you'll see in the file that we actually started this case with a 30-day notice rather than a 7-day notice. And we got the Section 8 payment through the end of the year, but we didn't get anything for January, so we thought there was an issue. And then when I went to file the case, my client said, and it's joint and several lease between Ms. Martin and Mr. Fletcher, that she said that she had moved out, and obviously she's taken her voucher somewhere else. But Mr. Fletcher is there, so I had to proceed against both parties.
So I understand you want to proceed as to both parties, but Ms. Martin has said she's vacated, and that's actually buttressed by what you're saying regarding the voucher and the payment. So I'm going to allow a default judgment for possession as to defendant 2. I'm going to indicate that defendant 1, Ms. Martin, has indicated she's vacated the premises.
So I will put
And I also have court, oh, sorry.
I will put under further orders that the case is dismissed as to Ms. Martin and that the judgment is proceeding with respect to Mr. Fletcher only.
Yes.
So Ms. Martin, if you've got anything in the apartment that you want, you need to get it out.
Oh, it's been gone since November 26th. I have not been there.
Okay.
Okay. That's what I'm hearing. So, all right.
And I have text correspondence saying that I was leaving on that day. Everything, if you need any of that.
Ms. Martin,
Yes,
Ms. Martin,
sorry.
you're good.
Yep.
No, it's okay. You're good. I'm just doing it in this way so you don't get a judgment as against you.
I appreciate you.
All right. Thank you. You take
Have a
care
great
for
day.
for not knowing Zoom. You did a great job.
Thank
right.
you. Have a great day. Bye-bye.
You too. Bye-bye. Mrs. Haverkamp, LLC versus David Frame.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
And Mr. Frame, you may want to unmute. What is
Thank you, Your Honor.
plaintiff's claim?
The amount of rent that's owed in this case, including court costs, is $2,159.
Mr. Frame, how are you intending on getting that paid?
I would like to address Your Honor, saying that I did it during high school. I had business and criminal law taught by Mrs. Gail Yak, so I do know that the lease contract is, considered to be a contract by both parties, correct, Your Honor? There has been blatant disregard for security and repair in the apartment building that I live in. So I do believe that's blatant negligence. So I'm requesting that to be considered, Your Honor.
All right. So here's what I'm going to do. I'm going to order the defendant to file an answer. You have to file a written answer with the court. I'm going to order that to be filed by the 23rd, 2006, with all of the allegations that you're making. I will then adjourn this matter to the 24th, 2026 at 3 p.m. That is an in-person hearing. You'll need to show up, but the answer needs to be in the court by that time. And you need to make sure that defendant or plaintiff's attorney gets a copy of it.
All right. Can I get the court date again, Your Honor? I'm sorry.
The court date is April 24th, 3 p.m. in person.
Your Honor, may I address one more thing?
Yes, you may, Mr. Fenter.
Mr. Frame we had occasion to go into Mr. Frame's unit in the month of March because there was water coming from his apartment. He had intentionally taken the pipe out from underneath his sink and turned the water on. And so he flooded his apartment and other apartments in the building. And when we tried to address him on that, he made some strange allegations regarding security and stuff like that, that he thinks people were out to get him. Can we order him not to do that again? We can't have floods going into other units because of Mr. Frame's behavior.
All right. Okay, it sounds like that's something that we're going to have to deal with the entirety of that at the next hearing. So, Mr. Frame, get your answer in. We'll see you in a week.
Oh, what's the courtroom, sir, Your Honor?
The courtroom?
Yes.
It's courtroom C. You're in the access point. It's the one furthest down the hallway.
Okay, and what I have to bring evidence of, and what would that include? Eyewitness accounts? I don't have a phone or a cell phone.
The first thing you need to do is file an answer to the complaint so I know what your allegations are.
And where would I get that paperwork, Your Honor?
You can fill it out on a general answer form. You can get that from the clerk's office, which is right outside the door of the room you're in.
All right. Thank you, Your Honor.
Thank you. Mrs. Haverkamp versus Brandy Daniel.
David Fanter on behalf of the plaintiff. I think there's a second defendant, Your Honor.
There is Allison McPeak. Daniel. You may proceed. Neither are here.
So the amount of rent on this case is $1,420. Court costs of $188 for a total of $1,608. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff. That's by default for possession. We'd absent about any amount requested with a writ to issue in 10 days. 103 South Huron LLC versus Joshua Bertram.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
Mr. Bertram, I think there he is.
Good morning, Your Honor.
Good morning. All right, what is plaintiff's claim?
The amount of rent and court costs in this case is $1,815.
$1,800
and 15. 1815.
1815. All right. Bertram, how are you intending on getting that paid, sir?
I'm going to be picking up a second job. I've lost almost half of my hours, which is a big reduction in my pay. So I've been struggling to pay the rent, and because of what I get paid, I don't qualify for assistance. So I'm going to be working.
Have you tried? Hold on. Have you tried talking to Hawk?
Yeah, you have to go through the state of Michigan, and if you get denied from the state of Michigan's, the Secretary of State, or I can't remember.
DHHS.
Yeah, and then they bust your barriers, or I can't remember.
Yeah.
I've tried it, but I just, because of my pay wage, I don't make. It told me I have to be making $13 an hour to qualify for assistance.
Your Honor, may I?
Yeah.
As you're aware, there's a new program with MAP, which has a little bit higher numbers than SOS, so I think he should call the SOS because they can refer him over to MAP, or he can just go on the MAP website and fill out an application. And Zachary,
well, he can do that. Mr. Bertram, what I'm going to suggest you do is call Hawk again.
Okay.
Okay. And there are different programs that are available. So go ahead. What we're going to say.
I was just going to let you know, I have been trying really hard. And again, I'm going to be put in several applications for different warehousing jobs. So I would be working from 7 to 3 and then 4 to 11, 7 days a week.
All right. Here's what I'm going to do, sir. I'm going to adjourn this at this point to the 24th, 2026 at 3 p.m. Okay. Why don't you get back on the phone with Hawk, see what's there. Now, let me ask you this, and I know things have been tight. Is there anything that you can pay between now and next week?
I literally have $200 in my account right now, and I just got paid on Wednesday.
Okay. Mr. Bertram?
I've dealt with Mr.
Just
Bertram
hold on
before.
to that.
Yeah, I'm okay with that.
And we'll try to figure it out, but give a call over to Hawk and let's see if we can get you out of this hole and then you can move forward. All right?
Yes, Your Honor.
All right, Mr. Bertram. You take care. Have a good weekend. We'll see you next week.
I'm sorry. Can I write down the day that I was supposed to be coming in?
Sure. It's April 24th at 3 p.m.
April 24th, 3 p.m. All right, I'll be there. Thank you.
All right, thank you. All right,
That's all for me, Your Honor. Thank you.
All right.
I'll submit the two judgments. Have a great day.
You do the same, sir. Court stands in recess.
So are your bond conditions still remain intact? You have no contact. Okay?
Yes, Your Honor.
Thank you, sir. You're all set. Have a good day.
You too, Your Honor. Thank you very much.
Welcome. Roll call case of the state of Michigan versus Austin Knox. Case number 25S00281.
Tiffany Woods for people. Ashley Moten on behalf of Mr. Knox. Please state your name.
Austin James Knox.
Thank you. Here for final phone conference. This is the one where you guys were searching to get the video and we moved it from last month's jury selection docket to today's. Do you have your videos?
No, Your Honor. We are requesting to set this matter for a bench trial. And if we do not get the video, then we will have to proceed without it. He still has not received it.
May 12th.
May 12th, 2026 at 2 p.m.
Judge, hold on a second. I'm still trying to locate the case. So I don't know anything about a missing video. No one's reached out to me about any of this.
What your prosecutor should have put notes in the file. We had literally adjourned the jury selection about the video, and I believe they're requesting the video though. He's requesting the video because I think it's video from his house. I can't recall exactly what it is. It's Moten.
No, it's on his phone of the actual incident.
Okay, it's on his phone, so it's not coming from you.
Miss Moten, you're going to have to email me about this because I don't see absolutely any notes in the video about a video in our system from Miss Phelps. So, and I'm sorry, Judge, what date was this sent for? Is it set for?
Let me take a step backwards before I give you a date. So, sir, you're entitled to have a trial by a jury, at which time 7 people will decide. 6 people will decide whether or not you committed this offense. but you have the right to waive that if you so choose. Is that what you want to do? Waive your right to have a jury and go with the bench trial? That means that I'm the judge of this court and I will be making the decision. Is that what you want to do, Mr. Knox?
Yes, Your Honor.
Thank you.
I feel like your judgment's better than a bunch of random people.
Thank you. And does the prosecution waive?
Yes, Judge.
Now we can go back to May 12th, 2026 at 2:00 p.m. would be the non-jury trial date. The bond will continue. Ms. Moulton, you're gonna reach out to Ms. Woods about the actual video so she understands at least what's going on.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Welcome. Have a good day, everybody.
You too.
The court call case of the state of Michigan versus Daniel Ryder, case number 25S00139.
Tiffany Woods for the people.
Ashley Martin on behalf of Mr. Leiter. Please state your name, sir. You have to unmute.
Mr. Ryder, something's going on. Oh, you need to unmute your device. It's still muted, sir. You have to push the little microphone button at the bottom.
Can you hear me now?
I can. Please state your name.
Now? Hello?
Please state your name, sir. Yes.
Daniel Leiter.
Thank you. Great. Here's the final suit on the conference.
Yes, Judge. The victim in this case is Chelsea Bozell. Chelsea Bozell, if you're present, please unmute your device and state your name for the record. Chelsea Bozell. And Judge, I do not see her on Zoom, so we would be unable to proceed.
We move to dismiss.
Given that the people are unable to proceed, I will grant the motion to dismiss. It is without prejudice, meaning if they're able to proceed at a later date and time, they could reauthorize this. Sir, I do know you are on confinement, so you may bring the tether back after 1 o'clock today, and all your bond conditions will be over.
Yes, ma'am. I live in Kalamazoo. Can I take it to anywhere other than Ypsilanti? Because that's a 4-hour drive.
Yeah, it's a 2-hour drive, but yes.
Well, two one way, yes.
But no, you have to take it back to community practice.
Ypsilanti.
Yes.
Okay. Well, okay. It has to be today?
No, it does not have to be today.
Oh, okay. Okay. Thank you.
You're welcome.
Yes, ma'am.
That's
it, right? Yeah.
You're all set.
Okay. Thank you, ma'am.
Thank you. The quote call case of Ypsilanti Township versus William Vincent, case number 26T00007.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Alexander Hermanowski with and on behalf of William Vincent. Your Honor, this is time and date set for a final settlement conference. And I believe the witness is present. The prosecution, the defense is ready to go to jury trial or jury selection, that is.
As is the people, Your Honor. So we're ready to proceed.
This matter will be continued on May 1st, 2026. And
Your Honor, you said May 21st or May 1st?
May 1st, May 1.
Your Honor, is there a possibility to have a different jury selection date that is the same day as the bench bar and I'm the one who's going to be running the whole show?
I'm aware. Unfortunately, every year it's on that same day. So the next date for jury selection, 1 second, I don't have any dates.
The next date would be July 10th, Your Honor.
The next date for jury selection is not to July 10th.
Okay, then we will stay with May 1st.
May 1st at 8:30 a.m.
Thank you, Your Honor. Thank you, Mr. Barnett. Mhm.
Roll call case of State of Michigan versus Kimberly Williams, 25S00511.
Tiffany Woods for the people.
Ashley Moten on behalf of Ms. Williams, please state your name.
I'm sorry, my name is Kimberly Williams. Good morning, Judge Washington. Good morning, Ashley.
Good morning.
Attorney Ashley.
We're here for final settlement conference today.
Yes, Judge. And the victim in this case is Kenya Williams. Kenya Williams, if you're present, please unmute your device and state your name for the record. Kenya Williams. Judge, I did not see her on Zoom and we'd be unable to proceed.
The defense moves to dismiss.
All right, given that the prosecution is unable to proceed, I will move your attorney's motion to dismiss. It is without prejudice, meaning that if they will proceed at a later date and time, then this matter could be reauthorized. Are you on tether or anything, ma'am?
No, ma'am.
Then all your bond conditions are now over. This case will be closed.
Thank you so much, ma'am. And Judge, ma'am.
We're fine. Ma'am, it's good. That's fine. Have a good day.
Thank you. God bless. And see you later, Miss Ashley. Thank you for representing me. Bye-bye.
Bye-bye.
Judge?
Yes.
It appears that the victim for Jawu is present on Zoom. Is there any way we could make a note of that so she doesn't have to appear at the next final settlement conference? Since defense counsel is here.
Is there an objection to that?
No objection.
Thank you.
Thank you, Judge.
Be noted. I'll remember. Thank you. Ma'am, you may leave. You don't have to be present at the next final settlement conference if we get to that point. Unless you want to, and she may want to, because she did write to the court regarding this matter. I believe everybody got a notice of that.
Thank you, Judge.
Roll call the case of the State of Michigan versus Joe Torres, case number 26 FB 1302.
Tiffany Woods for the people.
Ashley Moten on behalf of Mr. Torres, please state your name.
Joe Torres.
Thank you. We're here for final settlement conference.
Yes, the victim is Sharnice Young. Sharnice Young, if you're present, please unmute your device and state your name for the record. Sharnice Young. Judge, I do not see her present on Zoom and we'd be unable to proceed.
We move to dismiss.
Thank you. Given that the people are unable to proceed, I will grant your attorney's motion to dismiss. It is without prejudice, meaning that if they were to proceed at a later date and time, they could reauthorize this. I believe that he did have a bond that was posted by a bail bondsman. The bond will be released. Are you on tether, sir?
Excuse me?
Are you on tether or anything?
I don't think so.
Oh, you would know. All right. So, all right. Oh, your bond conditions are now over. You're all set, sir.
All right, thank you.
Thank you. Roll call case of the State of Michigan versus Jeffrey McCulla, case number 25S00347.
Tiffany Woods for the people.
And good morning, everyone. Karma Dadush on behalf of Mr. McCulla. Mr. McCulla, can you please state your name for the record?
Jeff McCulla.
Thank you. Final settlement conference.
Yes, Judge. So the victim in this case is Esteban Lopez. Esteban Lopez, if you are present, please unmute your device and state your name for the record. Esteban Lopez. And Judge, we do not see him on Zoom and we'd be unable to proceed.
Given that the complaining witness is not here and that the prosecution is not able to proceed, Your Honor, we'd move to dismiss this case.
Thank you, Carmen. Have a good day. Thank you, Judge.
Wait till Mr. McCulla. Wait till she dismisses it. Sorry about that, Your Honor.
Given that the people are unable to proceed, the court will grant the motion to dismiss it as without prejudice, meaning that if they were able to proceed at a later date, it could be reauthorized. If this is the only case holding, I think there's something else holding on. Then you could be released, but I think there are other things holding you. This case is closed.
Thank you, Your
What
Honor.
about, will the bond be released, Your Honor, or did I lose it? Did I forfeit it? There's like $100 bond on the case.
One moment. Yeah, I get a 1,010% in November. A third party get posted that, so you didn't. It has not been forfeited. It should go back to that third party.
All right, thank you, Your Honor. She can just come to the court and get a check?
She should call and they'll work out the best time for her to come pick that up, okay?
All right, thank you, Your Honor. Thank you, Carmel.
Thank you, Mr. McCulla. Have a good day.
You too.
Call the case of Ypsilanti Township versus William Epps, case number 25T70513.
Paul Barnett on behalf of the township.
And good morning, Judge, to you and your staff. Robert Burton Harris on behalf of Mr. William Epps, who was also present on Zoom, and we both consent to this hearing being conducted on it.
Thank you. Today's the entire final settlement.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
Judge, we will move for dismissal without prejudice.
Thank you. That is granted. Sir, like your attorney said, it is without prejudice, meaning if they're able to proceed at a later date and time, it could be reauthorized, but at this point, all your bond conditions are now over. The case will be closed. You should have, all right, you're all set.
Thank you.
Thank you.
Mr. Burton Harris.
The roll call case of Ypsilanti Township versus Jody Shovan, case number 25T00449.
Paul Barnett on behalf of the township.
Ashley Moten on behalf of Mr. Shovan. Please state your name, sir.
Jody Shovan.
Thank you. All right, we're here today for fighting some counsel.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
The defense moves to dismiss.
The township is unable to proceed. The court will grant the motion to dismiss. It is without prejudice, meaning that if they're able to proceed at a later date and time, it could be reauthorized. Sir, are you still in treatment?
Ma'am, right now I'm at a halfway house. I'm going to go back to a different treatment here within the next week. I have one question though. Am I able to contact her now?
You should probably. Let me see what kind of case is it?
It's an A and B.
All right. You should wait for 24 hours, sir. Okay.
Okay, ma'am.
Taking out a name.
She has my.
Okay, Mr. Chauvin, that's okay. You don't have to provide any more information.
All right. Thank you.
Thank you. Court call the case of the state of Michigan versus Amisha Solomon, case number 25S00498.
Give me what's from people.
Ashley Moten on behalf of Ms. Solomon.
We're here for final settlement conference today.
Yes, Judge. The victim in this case is Medina Grimmett. Medina Grimmett, if you are present, please unmute your device and state your name for the record. Medina Grimmett.
we believe that the stop was bad. We don't believe that the lights were prohibited, and we're going to have a problem with the search as well.
Okay.
So you said it for a pretrial
motion on that, for this issue?
I'd rather have a pretrial first, Judge.
Okay.
If that's okay with the court.
May 15th or after, it's your pleasure.
15th is good, Judge.
May 15th will be the pre-trial. 10 o'clock.
State of Ohio versus Iowa lots. Case number CRB 2641.
Change of plea.
Correct, the swap.
Yes, Your Honor.
All right, so she's in treatment, so I don't think there's any reason to do this screening. She's getting screened as part of the treatment, correct?
That's correct, Your Honor.
They're appropriate.
Yes.
You have a right to say something to the court if you want. Do you have any message you want to give me or explanation?
I'm sorry for my behavior and I am paying the consequences. And I remain to become a better citizen.
Okay. Well, it sounds like you're making some progress there. Do you feel like you're making progress in these areas?
I do.
Okay.
Yes. Becoming stronger, independent. Yes.
And you're from, I've got an address at Scott Depot. Is that where you're from? Or?
That was my last address. I'll be changing my mailing address this coming week. I'll be getting an ID of an Ohio resident.
Where are you from originally?
Huntington.
Okay, so not too far away.
Yes.
Well, I don't see any recommendation, but it looks, I'm just assuming that there's recommendation that you continue in the program.
That is correct, Your Honor.
Okay. How do you feel about that?
I believe it's the best thing for me.
Okay.
Also.
Well, good. All right, and since you're there, I'm assuming you don't have any money either, correct?
Right.
Okay. So what I'm going to do, I'll give you $100 fine, but I'm going to suspend it if you complete the program.
Sure.
Okay, because normally on this, I would give a $100 fine, but I'll give it to you, but I'll suspend it if you'll complete the injuries program.
Sure.
I'll order you to pay the court costs. I'll give you 30 days in jail and I'll suspend all of it if you complete the program at injuries. I'll give you 5 days of community service, but I'll suspend all that if you complete the program at injuries. And let's do a review hearing sooner than later for her. Let's make it May 26th. May 26th will be your first review, so I'll see you back in a little over a month, just because I want to check and see how you're doing.
Sure. Thank you.
So she'll need to go to probation and get her paperwork from there, which is pretty good.
Great.
Thank you, Your Honor.
Thank you.
Yes.
Thank you.
They're welcome.
State of Ohio versus Robert Helms. Case number CRA 261115.
All right, so this is a Rule 4. You posted a bond with Mr. Sowers. You're supposed to turn yourself into Belmont County. Tell me about that.
I got a court date for the 22nd of this month, 10 a.m.
22nd of April?
Yeah.
Okay. Well, here's what I'll do. I'll set a hearing after that. If they withdraw their warrant, which they will if you show up, then you're off up here. You don't have to come back here. I'm going to set a date. But sometimes people don't do what they tell me, promise me they're going to do. They don't follow through. So we'll find out. I'm going to set it for May the 11th. So you don't have to be here if your warrant in Belmont County is withdrawn. If it's not withdrawn, then you gotta show up here, tell me why it's not withdrawn. If you don't, you got a bail bond. So I'll tell the bail bond to do it.
All right.
They know what you need to do?
Yeah, I'll take care of it.
Okay.
State of Ohio versus Vincent Hughes, case number CRA 26195. Your Honor, he hasn't been picked up by the state of Kentucky.
Okay, so Benjamin Hughes had an extradition, which he waived the right to the hearing. Kentucky came and picked him up before today, so the case here can be dismissed.
State of Ohio versus Jacqueline Stiltner, case number CRA 26203, CRA 25146. Your Honor, she's also been picked up.
Okay, so they did not post a bond for her.
What?
No, they did. So we need to find out if she was supposed to turn herself in Knox County before today. So can we have someone check on that?
Yes.
Jacqueline Stiltner. Knox County, let's see if I've got case number for them. I do. The Knox County's case number, that's Mount Vernon, is 23, it looks like a CR, it's CR, they don't do A, B, CR 08019. So I'll read all this later in the document, just to check to see more.
State of Ohio recalls Jody Schroeder, case number CRB 26184. This is Mr. Stratton's case.
Any Mr. Stratton in the courtroom?
So she's already. Yes.
Have you seen your result?
I have not.
Check. Mr. Schroeder also.
Can I also note, Your Honor, that I'm currently prescribed Vyvanse, so it's probably amphetamine for that. I'm never sorry.
Do you have that with you?
I do not. I'm sorry. It's at home.
Okay, so what I'm gonna do then, I'm gonna delay your sentencing, because I want you to bring in your prescription for me.
Okay. Sorry, Your Honor.
If you test positive for amphetamine.
That's what I figured.
So, I mean, if I give you a week or so, is that enough time for you to bring it?
Absolutely.
Okay. But you can go to the pharmacy and get it if you don't have it.
Yeah.
So let's see. Your availability, Mr. Shovan?
Any date except the 11th and 18th of May.
I'm thinking next Friday.
Oh, next Friday, I'm good next Friday.
Okay. Nope, not next Friday, I try. I got a out of town that day, Your Honor. Better write that date down. So just bring that script. And just the balls right here. Let's do the 27th. Are you available the 27th of April?
I hardly do.
It's Monday.
Yes, I'm good that day.
Okay, 10 days. April 27th for sentencing will be your next.
Yeah.
Bring your description in.
Yes, sir.
All right, you're good to go.
Thank you, John.
You're welcome.
State of Ohio versus Anthony Merritt. Case number CRA 25103, CRA 25400, TRD 082201.
Anthony Merritt.
Judge, this was previously a bench warrant. I made the assumption he'd been picked up and was back on the docket. I don't know. If he's in treatment.
Preliminary hearing today.
Yeah, January, February, he didn't show, but I don't know where he is.
December 12th, and then you got arrested in January.
Right.
He had a hearing on January 26th. Now, it was continued February 13th after the defendant's request. I suspect that he wasn't here.
I think that's when the bench warrant went out, and
It wasn't, I don't see it. There's-
oh, okay. I had written down
today.
Okay.
April 17th.
I have had no contact. He's not contacted the office since probably that January date.
Okay, let me check, make sure he doesn't have a phone though. See, on one case, he was left to go, allowed to get a treatment, and it was changed center. To no work, so I think he does have the law. So the bench warrant, failure here.
State of Ohio versus Jared Sipple, case number CRB 25468, A and B, CRB 25555. This was set for trial as noon today. Special prosecutor in this case.
But Judge, what, there were co-defendants, and somehow there was a mix-up. Mr. Astor was going to prosecute the female, and Mr. Hill was going to prosecute Mr. Sipple. It got switched. Now it's back on track. Unfortunately, Mr. Hill is not here today, so we left it on as a pre-trial to give another date.
Okay, so you just need.
Just need a date, Judge.
Trial?
Yes, trial. We've had multiple pre-trials. I don't think it's going to resolve itself.
So
short of a dismissal.
Now, are they going to be tried at the same time or separately?
Soon the same time. I'm thinking, and I
So we got to coordinate Mr. Ashworth and
we do, but I think because my client at one point admitted ownership of the dogs, her case might have been dismissed because the dogs live in the same house, and one thing, they're my dogs, they're not hers, she has nothing to do with it. So I'd have to double check that though. He said we did that last time, so I don't
But
think.
it is Mr. Ashford's case.
What's her name, remind me?
I mean, that's what's on the law.
Emily, his wife, is the one that Mr. Ashworth is prosecuting. Philip is prosecuting Mr. Sipple. At some point that got switched around, I don't know how, but I do know that we've had multiple pre-trials and we're just at an impasse, like I said, short of a dismissal, so we do need a bench trial date.
Okay, well.
I could do the 22nd or the 29th of May with I've got 6 jury trials in the next 3 weeks. If nothing's said on those days trial-wise.
I've already set trials that day. Dates I've got open, 4th of May, 1st of May.
Let's see. Trials down in Ironton both.
Or the 11th of May.
Well, did you say the 1st of May?
1st of May.
I can do the 1st of May.
May 1st.
Yeah, I can do that. Then I can get into a bunch of trials.
Excuse me. May 1st for trial.
They can't drop that case, but they pushed it. Yeah. May 1st, noon. Which was? Why not? Put noon, you want to sit there all day that way. Noon, May 1st. All right, talk to you.
Thank you, Judge.
Thank you, Judge, appreciate that.
State of Ohio versus Melvin Christie. Case number CRA 26216. But you should have to hold him, Your Honor.
This is for arraignments. Melvin Christian. No, that's the city space. All right, sir, you're Melvin Christian? Yes, sir. I'm Judge Capper. This is what's called an arraignment hearing for you. So I'm going to go over what to charge you. You got a charge document against you. You got minutes. It alleges that on April the 16th of this year, you not only caused Barbara Christian to believe you caused physical harm to her person and property. That's a 4th degree misdemeanor under Ohio law, carries a maximum penalty of 30 days in jail, $250 fine. That's the maximum. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, to make the state of Ohio approve this charge beyond a reasonable doubt. Do you understand those things?
Questions about this submission in this situation?
Tell the judge they're working on it.
I never read it in the model.
Okay.
It's.
Well, then, I'm going to enter a not guilty plea.
We'll have to go back to the jail.
Well, we're going to talk about that. Do you want a lawyer? Do you have the money to hire a lawyer?
Yes, sir.
Okay, so you want to hire your own lawyer?
Yes.
Okay. What's the state's position on bond for Mr. Christian?
Your Honor, Mr. Christian's daughter is here kind of on behalf of her mom, who was the alleged victim in this matter, and we would not oppose an OR bond to a facility. So TCC, I believe, is working on securing a bed for Mr. Christian, and then he also has VA benefits, so I know his daughter is looking into that as well.
Okay.
So once we have that figured out, once we have a bed secured, we would not oppose an OR bond. But the victim does request a temporary protection order in the meantime.
Well, you need to assess him and talk with him, Mr. Wilson?
Yes, we should have an answer here shortly. His insurance did not cover through our company. We did not accept it, but we are looking into other options.
Okay, well, the VA has a lot of options in Huntington.
Well, one thing that my mother would like to see happen is to see him committed to the Chillicothe VA mental health, but we haven't made contact with them yet. This happened so quickly.
Has he been there before?
Yes, but it's been a couple years, it's 20 years ago or so. So it's been a while since he's been there, but we've been to the VA.
It's been 40 years short. Is this substance use related?
Yes.
Well, they have a brand new facility right across the river now, and I don't want to knock Chillicothe, but I've never had a good, let's just say this, they're not responsive. I try to get information from them, and they do not respond.
We had this problem before when he was admitted to King's Daughters for 15 days. My mom filed temporary guardianship. We were within days of doing permanent guardianship, and my mom backed out.
Okay.
She's a long-term, I would consider her, battered woman syndrome. And so she's ready now to follow through. And I told her I want to take that pressure off her, and I want to take control of her.
Have you talked to anyone at the Spring Valley veterans? We've got a liaison there, Amanda Rayburn. I can give you the phone number.
I would appreciate any of that. We need help.
They're very helpful.
Yes, I mean, we want nothing but the best for him, but we're just not able to do it on our own anymore.
Does anybody from the prosecutor's office have that contact information? I know Mr. Hill does, but he's not here. Let's see.
My mom is very fearful, though. She doesn't want him to come back home at this point.
I understand.
Your Honor, I got $13,200. I got $50 at my house that my wife and I.
That he can't find. He pulled it out of his savings account and has been hiding it, rat holing it around his house, and taking off doorknobs to try to keep my mom from getting it. It's very bad. It's very bad. He thinks he's hearing voices of men's voices, and they're not there. They're not there. He won't take his medicine correctly. He cannot. He needs to be in a medical facility. He needs help. He needs mental help. And it is substance abuse related, but it's also mental health.
Both?
Yes.
Okay,
He will not even take his Suboxone the right way.
Okay.
He crushes it up and snorts it and runs out, and they won't tell doctors.
No.
They lie, see, I'm sorry, I'm putting it all out there. My mom's ready to give depositions. She's just not able to stand in front of him. But she said she'll agree to a deposition and tell all the information. And we have documentation for the last 2 years of his behaviors. So and we know that he has advanced prostate cancer, and the doctors told him that people typically in his age or his state make it about 2 years, and we're coming close on that mark. And also he had brain cancer, and they told us that would come back in 10 years, and we're at 9 years. So we think there's something medically going on. He missed his.
Let's hold it right there. We're not going to resolve this today, other than find a place for him to go. So I just sent Ms. Waldo the contact information for the representative from the VA. So let's bring them in on the mix, and I guess put him back in the holding cell, and we'll see what we can come up with, and I'm going to order that you stay away from your wife while this case is pending. So you're going to sign something that you agree to that. So that's called a temporary protection order. And what's her name? Barbara Christian. Okay, we'll deal with this later. Let's get some, and Mr. Wilson, do you still want to talk to him, or Mr. Wilson?
Yes, we'll let them know as soon as we.
All right. We're going to have some people come back and talk. Sure.
State of Ohio versus Christopher Clark. Case number CRA 26214.
Sir, are you Christopher Clark?
Yes, sir.
I'm Judge Gardner. This is an arraignment for you on an issue. It looks like there's a warrant for you out of Pike County, so that's Waverly. So what happens in Ohio on that, if there's a warrant for a person and it's in a county that doesn't touch the county that you're located in, contiguous is the fancy word for it. So Pike County is not contiguous to Lawrence County, so you have a right to have a hearing to make sure I don't send you someplace you don't want to go. I can appoint a lawyer for you if you can't afford one. There'll only be the issue of whether there's a warrant there if I should order you to go to Pike County. You can waive that hearing. If you do that, I will give you a bond. If you can post it, I'll order you to go turn yourself in. If you can't post the bond, I'll order Pike County to come get you and take you up there for a hearing. It was on a no operator license charge, is what they're saying.
Yes, sir.
So, how do you want to proceed? Do you want to have a hearing here? Do you want to waive a hearing? Do you want to try to post bond here? What do you want to do?
I would like to try to post bond here and turn myself in.
Okay. And you still live in Wayne?
No, sir, I moved, the one was over 11 or 15 years ago.
Okay, what's your current address?
It's 2701 First Avenue, Lincoln, West Virginia.
Okay, so what I will do, I'll post it, I'll set a $2,000 bond. So what that means is if you've got $2,000, you can post it with the clerk here. And then when you go turn yourself in Pike County, you get all $2,000 back. I will let you use a bail bondsman if you want to do that. Then you have to pay them the fee that you don't get back. Usually it's 10%. So $200 probably gets you out. Then if you don't show up there, the bail bondsman has to pay $2,000 to the court, and they don't want to do that.
Yeah.
So they'll come get you and take you to the jail
Yeah.
to make sure they don't have to pay the $2,000. So what do you want to do? You want to try?
Pay $2,000.
You want to pay the 2,000 here? Can you get that done this afternoon?
I can get it done. Yes, she's here and go right now.
Okay, there's somebody here for Mr. Clark? Okay. The clerk's office to the right. We don't take checks. There's ATMs. You got cash, okay, great. Go see the clerk, post it, and then what I'm gonna do, so you're gonna post it by noon today. So what I'm gonna do, I'm gonna give you a week to get up there and turn yourself in.
Yes, sir. Thank you, sir.
So that's, what is that, the 24th? Yeah. Or get them, if you call them and get them to withdraw the warrant, that's all I got. As long as the warrant's there, then I have to honor it.
Yes, sir.
Once that warrant's withdrawn, for whatever reason, you made a deal with them or whatever, then we're good. But the warrant has to get withdrawn either by you appearing or them agreeing to withdraw the warrant.
Okay. Yes.
So what I want you to do, because we have court at 10 o'clock, and next Friday I'll have court. And I'm going to tell the prosecutor, if we don't have some documentary proof that the warrant was wrong, check, make sure the warrant was wrong. If it's not, then we're going to have a problem. So I want you to get out there before then. So I'm giving you until 8 a.m. That's what I'm writing down. Turn yourself in before 8 a.m. on the 24th.
Yes, sir. No problem.
Or if you can't do that, something happens, you can't get up there, providentially hindered. Means God stops you from going up there. You gotta show up here at 10 a.m. and explain to me why you couldn't get to Pike County and get this taken care of.
Yes, sir.
If you just don't, you blow it off and don't show up, then you're gonna lose the $2,000.
Yes, sir.
Okay. So here's what I've written down. $2,000 bond to turn himself in to Pike County before April 24th at 8 a.m. or appear in this court on April 24th at 10 a.m. to explain why he did not appear.
Yes, sir.
You understand then?
Yes, sir.
Okay, I've signed it. You'll need, there's a place for you to sign. So, and if your person goes and posts a bond, they'll send paperwork down to the jail to release you, so she can come down there after court's over, pick you up here shortly.
Yes, sir.
Okay, any questions, sir?
No, sir.
Okay, that's all. So I'm putting it on our docket for the 24th as a pre-trial.
State of Ohio versus Raymond Jackson, case number CRA 25352.
Yes, sir, you're Raymond Jackson.
Yes, sir.
Mr. Jackson, I'm Judge Capper. This is what we call an arraignment hearing, the purpose of which is to tell you what charges you have, what the possibilities are for those. Yeah, I have to tell you your rights first. You have the right to remain silent. You don't have to say anything, but we're on the record here, and it's not privileged what you say. So if you say something and admit something about your case, it could be used against you. You talk to a lawyer, when you're talking to a lawyer, that's all privilege. We can't use that against you. So less said, the better about the facts. It's not a trial today. I'm not going to throw the case out because you tell me some version of what needs to be done. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to have bail and to make the state prove his charge beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, so now I'm going to go over the charge with you. It's possession of drugs. The state's alleging that at Fayette Township on May 22nd, so this is an older case, May 22nd of 2025, so almost a year ago.
Yes, sir.
You knowingly obtained, possessed, or used methamphetamine, and that's a Schedule II substance. Carries a maximum penalty of a year in jail, $2,500 fine. You understand the charge?
Yeah, I did understand.
Okay, and do you have the money to hire a lawyer?
Yes, sir.
Do you have a job?
No, yes, sir.
Okay. Mr. Smith, I'll point you. Mr. Smith is going to be your lawyer. State's position on bond for Mr. Jackson, and I've got an address for you from Beaver, Ohio. Is that where you live?
Yes, sir. Yes, my parents' address. I do stay there, but I also stay with friends.
Here?
No, I was going to the friend's house from my parents. Is how when I got to know.
Okay.
And they found something else.
Ms. Waldo, what's the state's position on bond for Mr. Jackson?
Your Honor, we would not oppose an OR bond if Mr. Jackson was agreeable to be assessed for treatment.
He has Ohio Medicare, Medicaid.
And he's agreeable to go to assessment for.
Yes, he is, Judge.
Do you have Medicare and Medicaid both?
Yeah, I have to carry it.
I know some people have both.
Yeah, I have to.
Right, once you get disability, you have Medicare. So we may be looking at OVP, I don't know, who can, does anybody else can take Medicare? Okay. All right, I forgot which agency you moved to.
You have Mark, you have recovery?
Okay, we want to talk to him,
Yes, sir.
and then we'll decide, come back after you've done it. We'll decide the details. You're gonna come back, or we'll let you talk to somebody to get an assessment, we'll come back in and decide bond. So, today, that'll be today.
State of Ohio versus Emory Markle Jr., case number CRB 2938 A and Z, CRB 222694 A and Z.
You're Emory Markle?
Yes, sir.
Junior?
Yes, sir.
Mr. Markle, I've got it down from the record that you missed a review hearing on March 27th of this year on, and that looks like these are traffic things. No operator's license and a theft offense. Do you admit or deny you missed your review?
Yes, sir.
Do you have an explanation?
No, sir, I don't.
Actually, you had a bond up from, that you posted, I don't know how we missed that. February the 10th of 2026.
That, I don't know what that was. I was around and they brought me in here. I got picked up on these warrants and they brought me in here.
Yeah.
I thought it was.
You posted a bond. I did an order that you were sentenced to 16 days in jail for failing to appear, but you could post a bond to be released and show up for a review on February 23rd, which I think you did show up. You showed up on February, well, maybe you didn't. I've got 6 months to tell you that you're on that day. Then you showed up a few days later and got a ring. But then I said at the next hearing for March 27th,
Yeah,
you didn't show up.
I got a few hearings that runs down in Myers too.
Well, how'd you get picked up this time?
Oh, just driving that
Oh, you were a passenger? Were they speeding or what were they doing?
No, I think the iron thing.
Okay. How long you been in jail?
A couple days.
Well, I don't know. It doesn't look like you're ever going to do this stuff. You were ordered to pay a fine and do some community service. And well, you did pay a little bit on that. You paid $170 on one case.
Yes, sir.
I mean, let's see. You want to just lay it out in jail, or do you want to try to do this?
I'm gonna try to do this. And I actually was at the community cleanup up here.
Oh, were you?
Yeah.
When?
Saturday, like week ago.
Which one?
A week and a half ago at the Burlington Fire Department.
Was you doing it for irony?
I just heard that you could go up there, and I was up there. I mean.
Did you sign in with anybody?
I don't think
Yeah, because we would give you credit if you came and signed in and thought you were there to do community service, because some people just show up because they want to help out. They don't have to.
I didn't do it, that's what I did, I just showed up.
Yeah.
I'm
Okay.
just trying to do the right thing, I'm just trying to.
Well, these court days, you know, when you miss a court day, that's
Yes, sir. Yes, sir.
bad stuff happens, because you're going to get a warrant for not showing up. So you need to be a little more nervous.
Yes, sir.
As a lawyer, I'm really nervous if I'm late for a hearing.
Yes, sir.
Especially when, back in the day, when I was down the side of the county, because those judges were Judge Burton and Litton. They put lawyers in jail for being late. Not for missing the hearing, for being late for a hearing. They would put lawyers in jail.
The ones we got down are a little bit easier.
Yeah, well, it's the way everything's easier now these days. Back in the old days, that's what old people say. It was always tougher in the old days. So. But it was true, with those two guys, they were tough on lawyers. Okay, well, I'll let you try to do this again, because the jail is not gonna move. The jail's gonna be there, and you're gonna get a warrant if you don't do it, and if you don't show up.
Yes, sir. Yes, sir.
So let me tell you what I'm showing you still have left. You go 30 hours community service on case number 2938, $465. That was a theft offense conviction. The other one was a traffic charge. You go 18 hours of community service, so that's 3 days, $630 on it, and that was a driving under suspension. Okay, and you want to do it. You don't want me to just convert it to jail. I wouldn't either, because I visited that jail, but I wouldn't want to spend the night there. But I would act like I was scared of going back there and make sure I got to my places I'm supposed to go, my hearings, and be nervous about it if I thought I'd missed something.
Yes, sir.
You have a smartphone?
I have no phone.
You don't have a phone? You're the second person.
I have no phone.
I've been asking that question here for quite a while. You're the second person that's ever told me. But everybody has a smartphone. I was just saying. You can check your case by going on your smartphone to the court's website, pull up your name. It'll tell you when your hearing dates are. And the ladies here love to answer the telephone.
Oh, yeah.
We actually have telephones here. You can't text us and we'll text you back, like my kids. My kids won't answer the phone either. But they won't answer when I text them. But you have to call and ask the question, when am I supposed to be there? What am I supposed to do? And they love to look that up and tell you. You can do it yourself if you get a smartphone like everybody else. You don't even have to call. Okay, I'm going to give you another hearing date. Are you going to remember? Let's write it down and give it to me.
Yes, sir.
You'll probably lose the paper, but how could you get it? The information if you forget. How can you get the information if you forget?
Oh, I'm not gonna lose it.
All court. Somebody's got a smartphone that you know, so you can have them look it up. There's no excuse for not coming to your hearings. And it doesn't matter if you got it, unless being in the hospital, now that's a good excuse, but forgetting or losing your paper, that's not a good reason. So I'm going to set it for the 26th of May, and that's a Tuesday, not a Monday. May 26th is your next review complete. If you don't show up, what are you going to get? A warrant. Exactly. So act like that scares you. Do what you're supposed to do. Okay, that's all.
Thank you, sir.
You're welcome.
State of Ohio versus Brandon Masters, case number CRB 23-421.
So, more of the same. So you're Brandon Masters.
Yes, sir.
I'm showing that you missed a review hearing back in June of 25, so last summer. June 23rd, 25, you had a review hearing according to the record. It was on a theft offense. You didn't show up, got a warrant issued.
Yes, sir.
Do you admit or deny that?
I mean, I admit that I didn't show up, to be honest with you, I forgot about what court case was and,
Did you hear anything I was saying back there when I was talking to the guy just in front of you? Yeah, forgetting is not a good reason. Yeah.
I mean, I got two parole officers, I got three parole officers, but I'm reported to two, and they sent me, they made me come back to Columbus, Ohio, and I'm living out in Columbus, Ohio. I got a job as a full-time mechanic up there.
Well, that's good.
Started to get on my feet, and then this right here popped up, and, you know, like, I'm going to two different.
Well, it popped up because
I
you
know-
got a theft conviction.
I
Whose
know.
fault was that?
I know it's my fault, and,
From Walmart. You were shoplifting from Walmart, right?
yeah.
They got cameras in the ceilings. They got people they got the store detectives room. People, if you're gonna shoplift, do not go to Walmart unless you wanna get caught. That's the place to get caught. They are gonna catch you. I mean, use your brain a little bit. One, you shouldn't steal from people, but if you're gonna steal from somebody, it can't be Walmart unless you wanna go to jail because you got caught. Okay, and I ordered you to go to treatment. Did you do that? I got no proof that you ever went to treatment.
I went to, RRS and I went through that and I did all that. And then I went, when my parole officer wanted me to come back to, Columbus, I had to come back to Columbus.
Jeremy, do you know anything about this?
He's right.
He didn't complete it?
He had to go back up there. He completed it.
Oh, he didn't, he started with you, but he never
Yeah, I don't
completed
think
it? Okay.
I want to check the whole test.
Who's your parole officer?
I got, I got two of them. I got a lady out of Franklin County. Both of them got Franklin County, but one's,
Did you get picked up in Franklin County on this warrant, or?
Yeah.
So how long's it taking you to get down here?
it's been a week and a half, 2 weeks, something like that.
Yeah? So it wouldn't do any good to test you now. You've been in jail all this time.
I mean, I go to my,
Who you been working for?
Adams Family Automotive.
I do have a report from RRS back in, well, it was May of last year.
I go to two different, rehabs up there for outpatient. I go to, GAP, and then I go to, CMS, one for each one on parole.
Okay. You got a pretty good report.
And I did a bunch of community service while over at, RRS.
I don't have any proof of that either. You didn't pay anything on your fines and court costs. You just basically, I mean, you didn't do anything. You didn't do any of your community service, you didn't pay anything on your fines and costs, and you didn't come to the court when your word.
I went to
And Angel McKinney.
Good afternoon, Your Honor. Ellis Friedman on behalf of Barnes and Barnes. I've spoken with these ladies. They don't live together anymore, but they're going to be moving out by Tuesday. So I just would like to just adjourn the case a week just to make sure they're done.
Is that good with the two of you? Mm-hmm. Yeah, okay. Mhm. Just a week?
Yes.
They're gonna be moving out Tuesday. Right.
Yes, everything, they should have everything by Tuesday. I just have one question. I am currently pregnant and I can go into labor at any time. So what do I do if I?
Well, get out of here. No, I'm just, I'm kidding.
I just can't make that court.
Well, we're probably going to dismiss it.
Well, it's probably gonna be dismissed. If everything's out, it's likely gonna be dismissed. May want to contact Mr. Friedman's office just to make sure it's gonna be dismissed, and then you don't have to worry about coming back.
Okay.
Okay, April 24th, 2026 at 1 p.m.
Thank you.
All right, thank you. Barnes and Barnes versus Tyler Myers, that matters dismissed on those. Take care of it. Tile Farms versus Community Landry.
Good morning, Your Honor. Rachel Dornbush, Pallets Law, on behalf of the plaintiff.
Good afternoon, Your Honor. This is Vincent Kinty, asking to appear on behalf of Ms. Camilla Landry. I am a student attorney along with Catherine Perez Oviedo. We qualified to appear under Michigan Court Rules 8.120. We go to.
Is that why you put it in the label?
Yes, I had to remember, Your Honor.
Did you put it in the label so you'd remember?
Yes, I have to have a little cue. I remember last time. I had to get it right.
Yeah. Oh, we all remember the last time. So, okay.
Yes.
Gotcha.
Yes. And I'm under the supervision of Professor David Santacroce. But yes, happy to be here.
Permission to practice is granted. All right.
Thank you.
Okay, where are we on this case?
We are resolved, Your Honor. I am in the process of signing a conditional dismissal that I will be emailing to the court here shortly. And if the court wants me to put the terms on the record, I can, or if the court wants to pass on this matter while I send it over. Let's see.
No, we can put the terms on and we can.
Okay, I'm just CCing counsel on my email to the court. The court bears with me just a moment.
Not a problem.
Sio v. Landry, and I'm sending this to Miss Weidling as we speak. All right, Your Honor. So what I'm sending is a conditional dismissal, and it indicates that there is a rent to retain of $1,686.36 for the period due through April 17th. Court cost of $192 for a current balance of $1,878.36 which would be paid pursuant to terms in item 3. Item 3 says to see attachment A. Attachment A to the conditional dismissal, which has also been emailed over to the court, indicates that defendant's counterclaim is dismissed with prejudice. Plaintiff has granted defendant reasonable accommodation, which involves allowing defendant to make her rental payments via certified check, bank check, personal check, subject to the rules and regulations, should a check be returned for insufficient funds, or money order without accruing the $10 per payment surcharge. It also indicates that the amount in line 2D of the conditional dismissal will be addressed as follows. The $960 currently held in escrow will be released to plaintiff. Defendant shall pay $221.99 on or before April 27th, and the remaining balance of $696.37 will be waived. This does indicate that defendant is going to be responsible for month-to-month fees beginning May 2026 at the rate of $45 per month, which is in addition to the base rent of $915 per month and the water sewer charges, which are metered based on usage. I think that covers everything, but I will defer to brother counsel as well.
That's your understanding of the terms?
Yes, Your Honor, we're in agreement.
All right, fantastic. And what I will do, I do have it. Well, all right. Do we have, oh, there it is. Got it. All right. I will sign off. I will mark the file conditionally dismissed. Thank you guys for working it out.
Thank you.
Thank you, Your Honor.
All right. Good. And the two students, they probably won't be back before me before the term ends, right?
I don't believe so, Judge Simpson.
Well, you two did a fantastic job. Should be proud of yourselves. And it's been a pleasure having you before me. All right.
Thank you. We really appreciate your mentorship.
All right. You guys take care.
Bye.
You too.
Sile Farms versus Janelle Baker. And Baker. Hello, name?
Janelle Baker.
All right. Where are we on this case?
Yeah, so I have applied both to Sarah as well as Hawk. I was granted Hawk, granted me, so I don't know where it's in the Sarah because I applied yesterday, but I do have a tracking number. I talked with Hawk this morning, and based on the intake, I was granted a caseworker appointment, which is going to be Wednesday at 9 a.m. Over the phone. Although the intake person I was talking to this morning said that Hawk only goes up to 3,000, but my balance is 3,707.29 cents.
When did you have this appointment?
This morning. I applied to Sarah yesterday, and I applied to talk to Hawk this morning.
Okay, because it's not, I don't have her on my list that you talked to them, but okay.
Okay.
Talked to them this morning.
Morning. And I've got that paperwork to file.
Okay. So when's your appointment with
Wednesday at 9.
Wednesday, the 22nd?
Yeah. But what they also told me was that they only go up to 3,000.
Correct.
So they had me get a cashier's check for $707.29, which I have here. And I know that Sile Farms does not usually accept partial payment, but
Take the check to them. They'll take it.
yeah.
All right.
Okay, you'll take it. All right, I
They
can
will.
drop that off this evening. Yeah, okay. And then pending the decision on Wednesday, I guess, and then after that it'd be a Sarah decision. So that's where things are at.
And you're still teaching?
Yes, absolutely. I've been there almost 19 years.
Got it. Okay. So let's adjourn it out a week, see where we are.
Okay.
Get that money over to them.
Okay, I can drop that off tonight.
All right. So I'll adjourn to April 24th, 2026 at 1 p.m.
So April 24, 1 p.m.
Yes, ma'am.
Thank you.
All righty.
And you guys need that paperwork to file for the assistants.
General assistant, I'll take.
Thank you, Your Honor.
All right, thank you. Sile Farms versus Michael Moore. Michael Moore, not checked in. You've been previously sworn. You may proceed.
Thank you. Your Honor, there's rent to retain of $1,631.52. Costs are $192 for a total due of $1,823.52. We'd ask for a default possession only judgment with writ to issue after 10 days. Your Honor, just so the court is aware, one of the caseworkers from Hawk did reach out yesterday while I was out of the office, indicating that they are assisting, well, they requested documentation to assess Mr. Moore for potential funding, and I am in touch with Sile Farms to gather that documentation and to send over to them.
Okay, that happened yesterday?
It did happen yesterday.
Okay, and that's not on my spreadsheet either. Okay, all right. And well, judgment to the plaintiff, that's by default for possession, redemption amount, in the amount requested, writ to issue 10 days. Okay, Sile Farms versus Stephanie Vogel. And Corey Vogel.
Thank you. I wanted to make sure for it.
What?
Oh, before I approached, because you just said her name first, I was like, I didn't want to just walk up here.
I called the important one.
Right, for sure.
Just along for the ride. All right. All right. Where are we in this case?
Okay, so we called Hawk, as you know, previously known, and we didn't get approved for that. So after we left here last time, we were calling the MAP program. The issue with that is they said they only hand out like a set amount of them a month. So by the time we got out of the last court hearing and we called them, they said that they had already handed out like the maximum for the month. So they told us we could come back on the 1st and get it. So I'm actually like requesting that as long as we pay May's rent, so we stay under that $2,000, if we can apply again through MAP. So we stay under 1,000. Yeah. So we can stay eligible for the MAP program.
So the balance at present, Your Honor, is $1,895.79. There was a payment made of $280 earlier this week, or might have been on, I'm not sure if they dropped it off on Friday or on Monday, but in any event, they did make the $200+ payment that they had promised, but I don't have authority to adjourn it into May while we wait to see if they qualify for that program, unfortunately.
How much is their monthly rent?
It is $9.15 plus they have a $10 pet fee, and then water sewer based on usage, which looks to be 110, 120-ish, sometimes a little higher or lower per month.
Your Honor, we're also waiting on DHS to make their payment.
To make
Their payment that
I
they,
did forget about that. Thank you, Ms. Vogel, for the update on that. I believe DHS did approve a payment of, what was it, $581.70, I believe is what DHS approved. And so their payment of the $280 would cover the portion DHS said they were responsible for. It'd just be a matter of DHS releasing the $581.70 at this point.
What if we could pay May's rent by like next?
Okay, hold on.
Okay, sorry.
Trying to figure out how to get. I don't have any. When did you guys call Hawk?
the same day we got out of court.
I don't. There's.
I have the paper where they sent me a
They just.
file.
I don't have anything on that. Okay, that's not anything having to do with you guys. You guys are good. Okay, right. That's just more my frustration with people messing with the system. All right. It's okay. I usually crush those people when I get a chance. Did I say that out loud? Okay.
I heard nothing.
There you go. All right. So did you give me a number that their rent would be?
So 915, 925 plus approximately, let's just say 120. That's probably their average water sewer usage ish. So 925 plus 120, 1,045.
So if they're at 1895 plus 1,045, roughly speaking, I would be at 2940. All right. And so but then I take off that about 580 that DHS is going to pay once everything's paid.
I paid everything, so they should release the funds.
Pardon?
I paid what DHS expected, so they should be releasing the funds.
Okay.
They said I had to pay like $17.80 in order for them to release their portion, the 5 something.
Got it. So they weren't expecting a zero.
I think DHS, Your Honor, probably based their decision off of maybe the summons and complaint versus the current balance. And so their tenant portion didn't necessarily cover the current balance due, but that's what I was trying to probably ineloquently explain to the court is that Ms. Vogel, between her 2 payments, did pay the amount that what DHS recorded as the tenant portion based on their review.
It had at the time.
Yes.
And so the only thing is that then DHS, you're right, they should release it without you being at a zero. But if I look at this and okay, so I'm still going to be short, which is what the problem's going to be. Can you give me 2940 minus 581?
$23.50.
Okay. So you can probably see what I'm doing. I'm factoring in your
Next month.
pay rent, looking at everything that's going to be paid, and what gets you to where you're at the 2,000 come May 1. And based upon the numbers that I'm running, I'm about 350 short. Okay. So my question is, I don't have a problem because you went through that process trying to get you to May. If the 350 can be paid. So that then I just have a balance of
And we have till Wednesday.
pardon?
We have till Wednesday to pay that, 350.
Yeah, that's, so you think you can get that paid next week?
I'll pay
Yeah.
500 next week,
Yeah.
Wednesday.
Okay,
Yeah.
that's easy. Okay, so here's what I'm gonna do. I'm going to adjourn it out 1 week to make sure that payment's done. Okay, so you're gonna pay, I'll just say between 350 to 5, okay? Pay that. And then if that's done, then what I'm gonna do is I will do the adjournment to May. And see, the May date is gonna be May 1, so it's the 8th.
Yeah, because of the bench bar.
Oh, I'm not here on the 1st?
No.
Yay.
Forgot about or something?
That wasn't a vacation. She was reminding them of something important.
Uh-oh.
Oh, I am. That's
Not in this room.
all right, May.
Okay.
So what we would be doing is doing that.
Fourth.
Then you could do theoretically, I'm not gonna adjourn it at this point to that point.
Right.
But theoretically, what you'd be able to do then is get the application in May 1st.
Mhm.
And we hopefully can maybe have an answer by the 8th and get you guys to ground zero.
Yeah, they said to call first thing in the morning on the 1st, and they said it shouldn't have a problem proved. They just, I guess, only let out a limited amount of them because of the income bracket.
Exactly. Exactly. All right.
And since we were so late in the month after the last hearing, they already used them all up.
Okay.
Yeah.
All right. So you guys will be all set, and then we'll see you next week at what time? 1 p.m.
Okay.
And that's basically, I'm really just checking
To make sure
sure that held up and done, and our numbers will relatively match up, and then get you into May.
All right. Thank you.
And I'll do that over plaintiff's objection to the extent they have an objection, but
Thank
I
you.
don't think they shouldn't have, because
We're really trying.
Yeah, we are trying.
math with me. All right. Okay, folks, okay?
All right.
Have a great weekend.
Thank you, Your Honor.
Case.
Oh. Okay. Let me recall the case of Silo Farms versus Michael Moore.
Is Mr. Moore, oh, there we go. Okay.
Yeah,
Sorry, I was running a little bit late this morning.
he was running late and here the last time, so okay. You defaulted your balance currently is 1823.52.
Yeah, I talked to Autumn at Hawk on Wednesday, and she's pretty confident that they're gonna be able to help me. I sent the rest of the paperwork that I needed to send her, and she said she was
How
gonna
do I not
contact the
know
court.
that from looking at this sheet?
She said that she was gonna contact you guys, but it was just the day before yesterday.
No, it's not, that's not your fault. They send us a sheet to tell us, you weren't here telling me this, I would have no way of knowing.
She did say to make sure that I came and told
Oh, I know, but they
money or not.
can't work that way because, okay. So I'm not going to enter the judgment. You sent in all your paperwork.
Yeah, I'm just waiting to hear back from her.
I'll adjourn it. I'm going to adjourn this case out 1 week.
Okay.
24th, 2026, 1 p.m. Be on time this time.
Okay.
Okay.
All right.
And I'm going to adjourn it out. Let's.
Okay. Thank you.
So, put on that day, I ended up issuing a judgment against somebody that was in the middle of the process. It's crazy. Arbor Woods versus Elisa Franklin. Elisa Franklin, not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of 3,000.
I'm here, right here. I'm
Oh, okay. Oh,
Yes.
Lisa's, of course we know that, right?
I'm always going to show up.
Pardon?
I'm always going to show up. I explained to them last time I came on the LA. So what has happened is, unfortunately, I had a double tragedy. I lost both my parents and stuff about 2.5 weeks ago, with almost 3. So it's just me and my sister. They had no life insurance or anything. This is the reason why we're here. I've been making payment arrangements to the funeral home. So I do have 1780. That's for April. But because I'm on the for March, but because April's already attached, it's considered a partial payment. Okay. So I won't have
Okay. Slow down.
Okay, go
Slow
ahead.
down, Ms. Franklin. You
Okay.
have 1780.
That's for March.
No, just I need to know the dollar figure you have. What do you have that you can pay to the landlord?
No, that's what I'm trying to explain to you. April's already on there already. So it's 3,000 it's 3,000 or something now, but they can accept it's considered partial payment because it's the whole
I know,
dollar
Miss
amount.
Franklin. Miss Franklin,
Yes, Judge
answer
Simpson.
my question. How much money do you
1780.
have that you can pay to the landlord?
1780.
And Your Honor, if Ms. Franklin drops that off in the form of a money order or certified check, they will take it.
Okay. I'm glad you said that. Thank you. Because when I go in there, it's
Well,
considered.
that's what we were trying to get to about 5 minutes ago.
Okay.
So get that over to them.
Okay. Okay.
When can you get that to them?
I just gotta take it off my card and stuff because I usually pay it through the portal. And so since I'm locked out the portal, so my account, then I have to pay $10 per money order or cashier's check. So that means I have to get additional couple dollars for that. So can you, what's today, day Friday? Can you give me over the weekend and then I can get the other the difference of
Can
that
you
time
get
to
it
pay
there by
extra?
Tuesday?
Yes, I can get it by Tuesday.
Okay.
Yay.
Then get it there by the 21st.
Okay.
Okay.
Now, okay. What about April?
Okay. So I'm going to adjourn. You get that paid.
Okay.
I'm going to adjourn it out to next week, the 24th,
Okay.
2026 at 1 p.m.
Okay.
All right. And
All
then
righty
you may
then.
have to figure out, you can call Miss, after you pay, you can call Miss Dornbush, the number that's on the paperwork, and see if they're willing to work out an agreement with you.
Okay. I don't have the papers. Anyway, she can on the side or something so I can get her number. If I don't have her number.
Ms. Franklin, 9 numbers on the paperwork that you received to be here in court today. Also, you and I have corresponded previously via email. I can.
Just email me again. Just email
I'll
me
send
again.
I'll send you an email
because
right
I don't
now.
keep the paper. Yeah. I appreciate you guys. Thank you so very much. Okay.
All
So,
right. Thank you. We'll see you next week.
Okay, so 1 o'clock, correct?
Yes, ma'am.
Okay, thank you guys.
Thank you. Arbor Woods versus Reginald Hughes. And Felicia. How come the one I like better doesn't show up? How come it's always him? Anyway, never mind. I know. That was wrong of me to say, but it's true.
Look,
All right.
I even told her, I said,
All right. How much do we have owing?
Your Honor, unless Mr. Hugan made the $1,100 payment that he had indicated he was intending to pay today, we've got him at $2,288.96. But if he did drop off that $1,100 payment, I need to verify that with my client.
I didn't yet.
You didn't do it?
No, I didn't know.
Why? Don't have it.
Didn't work. I just left work. I got to go back to work. So I've been working long hours trying to make this money to pay it. So I will be having it in by Monday for sure. I got to work today, tomorrow.
All right. So, well, you're going to pay. So you're going to pay the 11 by the 20th, but then what else can you pay?
In 2 weeks, I have everything. I have everything. Everything be paid off. I know that'd be like on the 1st, I know that'd be cutting it close.
Well,
Not,
It's not gonna-
unfortunately, not close. It's that May would have to be included in that. But Your Honor, I mean, I'm happy to have a conversation with Mr. Hugan and see if we can reach an agreement.
okay.
Okay. Do I need to?
Here's what I'm gonna do. I'm gonna adjourn it out 1 week.
Okay.
24th, 2026.
Okay.
1 PM. You need to contact Ms. Dornbush.
Okay.
And see what you can work out. But you know, Mr. Hugo, you know how it works. If you tell me you're gonna pay something, you gotta pay it.
Yeah. Oh.
Told the court the last time you'd have that in. I get working and all of that, but the landlord's counting on that. So the 1,100 needs to get in.
I didn't tell.
Well, you were gonna pay it today.
Yeah.
All right.
I'm sorry. I apologize.
So you just gotta get that in.
I apologize. Yeah.
All right. So get that to them.
Okay. Now it might be in the Dropbox tomorrow. It could be, or tonight.
All right.
I'll, I'm
Get it in by Monday.
Yeah, I appreciate
We'll see you next Friday. Call them.
Thank
you. If we can work it out.
I apologize and thank you.
Not a problem. No need to apologize. You just know how I work. You just need to do it. Okay.
Yes, sir.
All right. So if you're not going to do something, send Felicia because I'm up to her. All right.
Guys, have a blessed evening. Thank you.
Arbor Woods versus George Jones, the fourth. Hello, your name?
George Jones.
And how much do we have owing?
1887 and 44 cents.
All right. They're on the sheet.
I was going to say, I spoke with Kara today over at OS, and she said she was going to make sure that I was on the sheet.
I have here met with you on 4/16, need client documents. Did you get those?
I just got them 20 minutes ago. Been checking my email.
I'm sorry?
I just got them 20 minutes ago. I've been checking my email. She just sent documentation, the documents that I have to sign as well as my kids have to sign.
Oh, okay. And then we'll reach out to the landlord for a ledger and a W-9. So it looks like it's gonna happen. So I'll adjourn you out to next week, 24th, 2026, 1 PM. Okay. So you get those things in, then they're gonna, I don't know if they explain the process, then they're gonna reach out to the landlord and get the documents and hopefully we can get
as soon as I get home, I will get this, get it straight.
All right. Thanks.
All right. Thanks.
Arbor Woods versus Kiera Morris. Kiera Morris. Ms. Morris, is that you? I'll
Star
need you to do
six.
star 6. Yep.
Can you hear me?
Yes. Are you Ms.
Hello?
Morris?
Yes.
Okay. All right. What's plaintiff's claim?
Your Honor, with cost $1,219.33, and I emailed over to Miss Weidling probably about 20 or so minutes ago. Maybe I'm not exactly sure what time. In any event, it's a conditional dismissal with some terms.
Oh, okay. And I do have it. Come to think of it. All right. And this indicates that a total amount of the
It should indicate, Your Honor, that Ms. Morris is going to pay a particular amount of $828.71 on or before Monday. And when she does that, my client will waive the difference of I'm so sorry. That was supposed to be $390.62, not $392.62. Apparently, I can't type today.
It should be
$390.62. Yep.
Oh. Got it. Okay.
And this
that
would be
will
in full satisfaction of all prior disputes between the parties. So we're starting fresh with Ms. Morris.
All right. Ms. Morris, is all of that correct?
Yes, sir.
All right. Do you have any questions regarding the conditional order dismissal?
No.
No? Because you're unrepresented by counsel, you have 3 business days to think about this. You believe there's some right you didn't assert, some misunderstanding on your part, or some confusion, you'd have to file a motion within those 3 business days. Doesn't mean I'd grant the set aside, but you'd have the time to do that. You understand that?
Yes, sir.
All right. I've signed this, marked the file conditionally dismissed. Thank you guys for working it out. Take care. Have a good weekend, Ms. Moss.
Thank you. You as well.
Arbor Woods versus Sanaja Thomas. And no, just stuff. I said the name right. I did. Hello. What's your name?
My name's Sanaja. And I'm mom, Tanjanika.
You're her mom? I wouldn't be able to tell by looking at them, would you? All right. Yes, you do favor each other. All right. So what is owed here?
$3,282.22. I know there was a indication of a plan to pay $1,700 today, but I don't know if that got in before the ladies appeared for court.
Right. Okay. What happened?
Get in. I've been in the hospital with my daughter, so my check was really low. I didn't know my daughter had a baby and she had complications. I have another daughter, and we just got out, and I'm tired, but I was just trying to see if I can wait till Wednesday. I could pay like almost 15 Wednesday. Could. And okay.
So grandmother blame it on the baby.
I'm not blaming it on the baby.
No, I'm
sorry.
I'm just messing with.
Sorry.
All right. How's mom and baby doing?
They better. They at home.
Okay.
God, yes.
That's the important thing,
Yes.
right?
Yes.
Okay. So you think can't do the 17 because you were there doing.
Yeah.
Got it.
Yeah. It's a lot.
All right, but you think you can pay 15 by
On Wednesday. Yeah.
on Wednesday? All right. And then what's the plan for how you're going to get the rest of?
I'm gonna call DHS. I'm talking for my daughter because I'm trying to help her out. But I'm gonna call DHS. Put in because we put in for one a while back, but I ended up paying that, and they told me I had to do another one. But by me being in the hospital, I wasn't really able to do it.
Are you working?
Yes, I'm working.
Have you gone over to Hawk?
I called for her. They said we make too much.
All right. So here's what I'll do. I'll adjourn this to April 24th, 2026 at 1. You're to pay the $1,500. You need to make sure that's paid on Wednesday, the 22nd.
Okay.
All right. Then I want you to call Ms. Dornbush's office, see whether or not you can work out some agreement for the payment of that balance.
Yes, sir.
All right, because you're getting kind of close to May.
Yes.
So we gotta
Yeah.
try to do it. All right.
Yes, sir.
Okay.
Thank you. Thank you.
You're welcome. Courthouse case, what was it for those? Northville Crossing versus Jennifer Kramer. And David Doble. There he is. Hello, sir.
Good afternoon, Your Honor.
I'm sorry, Your Honor, was Jennifer Kramer present?
No, Jennifer Kramer is not present. All right. What is the claim?
With costs, Your Honor, $1,961.59. And I apologize, Your Honor. And looking at my notes, I do see at the last court date that Mr. Doble had indicated that she may be incarcerated somewhere. Do we know where she's being held?
She's currently in Oakland County Jail.
Oh, okay.
Oakland.
All right.
Yes, Your Honor.
Okay. All right. Yeah, that's what I see from the notes here. Okay. All right. So, sir, how are you intending on getting this paid?
I get paid next Friday, and Jennifer's mother agreed to help me out. She gets paid same time next Friday with the remainder of whatever I can't cover. I should be able to pay around $800 to $1,000. And she agreed to help me out with the remainder. I had difficulty applying for rental assistance with Hawk and various other options, as she needs to be a part of the intake process.
Exactly. All right. So you think you can do 800 to 1,000 definitely by Friday, the 24th. How soon can you get that in, sir, on Friday?
Probably anytime after 3. I usually get off around 2, 3 o'clock.
Okay. All right. And then, because the hearing, if I turn it out a week, is going to be at 1.
Mm-hmm. Oh, yeah.
Okay.
I could request to leave early. My employer's working with me with all this, so he doesn't have a problem.
Okay. So whatever you could do to try to get that into them so we can have some verification that it's paid, then it gives a little bit more flexibility going forth. I'm sure you get that. But.
Yes, sir.
And then her mother, you said, is going to help out, but we don't know when that'll come in or what that's going to be, correct?
She's agreeing to help with whatever the remainder of whatever I can pay to try to get this like totally resolved.
Okay. So if you were able to come up with 1,000 or somewhere near there, then there's going to be another 1,000 there. So, or thereabouts. So let's do it this way. I'm going to turn it out to the 24th at 1 p.m. Get that payment in, get in what you can get paid in. In the interim, because it looks like everything can be taken care of, call Ms. Dornbush's office, see if you could work out an arrangement as to when those payments will be in, and there could be a dismissal. All right.
Yes,
worst case scenario, if you guys get that all in on the 24th, then I might, if I can see that something's been paid, I might adjourn it out to the 1st of May, but everything get taken care of before then, and then the case get dismissed. If you follow me. Okay.
Yes, yep.
All right. But get that in so we can see a payment, and then we'll go from there. And feel free to call Ms. Dornbush and see if you can work something out. All right.
Yes, Your Honor. Understood. Thank you.
All right. Thank you, sir.
Have a good day.
You too. Spice Tree Apartments versus Ashley Drummer. Ashley Drummer, not checked in. You may proceed. Okay. I'm sure. Is there no? Hold on. All right. Hey, I have a note, Ms. Dornbush, that SOS is planning to pay this once a co-payment of $99.27 is made.
Okay.
I don't know. I don't have a live person here, so I don't know when they arranged that, but has there been a payment of
There
about
was
100?
a payment of $1,404 that was paid on the 15th, so day before yesterday. And then
Right.
my notes
She
from the
said-
last court date was that she was denied by DHS, but that she anticipated Hawk helping her if she got the balance paid below 3,000. Right now I've got her at $31.99.27, but that does include a late fee, and so they may have looked at the balance prior to that late fee charging and said $99.27 is what I'm guessing.
Right. And she's not here. Was she? This wasn't the one that tried to call
Try to call in today.
or tried to Zoom.
No. We already handled it.
Okay. Well, you'd like to take a default, then I'm going to allow a default. I see what this says, but she's not here, and the amount she's had to pay went up by 100 and hasn't been paid. So I don't know what her plans are. So
I appreciate that, Your Honor. And I will let my client know that there is potentially assistance coming from Hawk and you know, that they should continue to communicate. Is that Miss Drummer right there, Your Honor, that just walked in?
Drummer? Your name? Okay. No.
No? Okay. I'll let my client know that there's potentially assistance coming through, that they should keep an eye out for communications from Hawk to see, you know, where things stand with that and any sort of anticipated time frame for that to come through. Rent to retain, Your Honor, $3,030.27. Costs are $169 for a total due of $3,199.27. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested with the writ to issue 10 days. Valley Ranch versus Shawnee Moore.
And Your Honor, Mr. Moore and I were in communication earlier today about a potential resolution. I did not have an answer for him prior to court to be able to relay to him. Mr. Moore had requested and set forth terms for potential payment arrangement, which my client indicated they were not able to agree to. At present, the only authority that I have is for payment within the statutory 10 days, which would be on or before April 27th. The total balance due is $3,562.01.
All right. Your name?
Shawnee Moore.
All right. Ms. Moore, how were you intending on trying to get this paid?
I just got a new job. I just started work. So
you're not gonna, well,
yeah, I'm not gonna be able to
wrap it up before the end of the month, or no? Because it doesn't sound like they're willing to offer a payment plan to do this.
Yeah, I might be able to get all of it by the end of the month, once I get out there and start working, because the money comes pretty quick.
Okay, so here's what I'm gonna do. I'm gonna grant a judgment finding no tribal issue to the plaintiff for the total amount of the $35,62.01.
Yeah, and I talked to
yes, 3562.01.
I spoke with Hawk, and they said I'm just waiting for them to send over the contract for the new job. They said they would be able to help me after that too.
Oh goodness, really? So he's not on our list here. All right, so tell me about that again, sir.
Yeah, so I
talked to Hawk.
I talked to Hawk. They said because I told them about the job and everything, they said once everything with that's cleared, call them back and they should be able to help me.
All right. And then, so the issue, so here's going to be part of the issue.
Okay.
At least as I understand it. So when you went to talk to Hawk, you didn't have a job, right?
Right.
And so they need to find some way that's your ability to stay there, you can sustain it.
Correct.
Help, right?
Correct.
So now you have that, you can go back to Hawk.
Yes.
Okay. And then you'll still need, if they can help you, you'll still need to pay $562.
Correct.
1 cent.
Correct. They told me that. Correct.
They told you that too.
Yes.
Right. So you got to pay it down to the 3,000.
Yes. They said they take a money order or.
Got it. Okay. So I'm going to still grant the judgment finding no tribal issue. I'm going to make the writ date or the date you still got to pay by the end of the month.
Okay.
Okay. So what I'm hoping is going to happen now, hearing that information, you'll be able to get that paid to the 3,000. You'll show them that you have a job. They'll get a check, cut it to the landlord for the 3,000, and then you're all set.
Okay.
Make sense?
Yes.
Okay. Fantastic. All right. Thank you, sir.
All right.
And Northville versus Patricia Johnson. That matter is dismissed on plaintiff's motion without prejudice. I think that's it, Ms. Thornbush.
I must concur, Your Honor. Thank you so much. Have a great afternoon.
You do the same.
Thank you.
Court stands in recess.